Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. We are all lucky because to my right is Justice Henry and to my left is Justice Walsh, two of my outstanding colleagues. We will be hearing
every time.
about you, Justice Walsh. I do. I say it every single time. We are hearing 6 cases this morning. The rules are, as they always are here, 15 minutes per side and no rebuttal. The first matter we'll be hearing this morning is, my thing says SORB number 97,000. I would think it would be DOE number 97,000, but there it is, versus Sex Offender Registry Board, number 231024. I remind counsel that this is an impounded case, and so we don't use actual names. And we will hear first from Attorney Caffrey.
Thank you, Your Honor. Good morning. I'm Attorney Colin Caffrey, and I represent DOE 97,000, the appellant. DOE committed his last offenses when he was an emerging adult. Those offenses occurred up until approximately 1/5/2003, and he pled guilty on 11/15/2004. And he was then sentenced to 8 to 20 years in prison. He has now been released and is living in community and employed. DOE also had an earlier victim when he was 13 years old. DOE moved both before and at the hearing for expert funds, and that motion was denied. He moved for expert funds specifically to opine on how his emerging adulthood affected his risk of dangerousness and reoffense.
So what I don't understand about your argument, and this is an argument that's been made now to this court by a few different DOEs, is that he's not an emerging adult now, right?
That is correct, Your Honor.
He's how old is he now?
He's in his early 40s, Your Honor.
So why would, they're looking at the risk of reoffense at the time of the hearing, right?
Yes, Your Honor, but I think that goes, as the Supreme Judicial Court said in Mathis, that young adults, emerging adults, have more of a capacity for change. And as they grow up, as they mature, they become less likely to reoffend. They become less dangerous. They become less prone to risky behavior. They have better impulse control.
But why do the SORB regulations not account for that as the regulations are now?
Your Honor, I don't know why the SORB regulations don't account for that, but that is exactly why he needs an expert, because he's identified a unique circumstance that is not covered by the regulations. Now, I'll speak both to the case law, which has been cited in my brief, and I'll also
Back up for a moment just to jump on Justice Henry's point, which I'm troubled by as
Yes.
well. How, in other words, did that factor into the hearing examiner's determination that your client now is a moderate risk? How did his age at the time of the offense as a young emerging adult impact when he was, I believe, 38 at the time that
Yes.
she determined? Where does that fit in?
Well, Your Honor, I think the hearing examiner, and laudably, to her credit, she did take it into account. She mentions in her decision that she was taking into account his youth, and she was taking into account the progress he made. But that alone isn't sufficient. He was still entitled to an expert to opine on why that is. I would cite to that.
Well,
Yes.
that may be where
Yeah.
I'm not sure that the case law would suggest. So in other words, if a decision comes out and is in your favor, but you said, well, I should have had an expert to have someone, say, with a degree at the end of their name, the same thing that the decision said, that's not true, right?
Well,
So can you work with me just on why it matters? He was an adult, charged in an adult court, and we're determining whether the hearing examiner's denial of expert funds was an abuse of discretion, correct?
yes.
Okay. How would it have helped since she already factored that into your client's benefit?
Well, I don't think that this was a slam dunk case that he was going to be a level 2. I think the case law shows that even if you're reduced to a level 2 from a level 3, that can still be prejudicial because you could have been reduced to a level 1. And I think this is a case where he certainly could have been reduced to a level 1. At the time of the hearing, he had been offense-free in the community for, more than a year. He had completed his sex offender treatment program. He was participating in the graduate support treatment program. He was actively participating in therapy both while incarcerated and afterwards. And he had successfully completed therapy. I think at one point, one of the therapists says he utilized treatment effectively to work through his self-worth in a meaningful and emotionally connected manner, and that he challenged his distortions. This is someone...
So to be clear, counsel, I mean, we applaud that. I mean, it's
Yeah.
great that he's doing those things, and I hope that he continues to do those things, and I think he'll see benefits in his life from doing them. But SORB cites Doe 526-500, which is an unpublished decision of ours that concludes that an 18-year-old is not a juvenile, and says, we fail to see how the plaintiff's status as an adolescent is a condition or circumstance special to him that would justify the granting of expert funds. So is that case wrong, or, I mean, I know it's not controlling because it's not published, but is it wrong? Or is it somehow distinguishable from this case?
Well, Your Honor, I think it's wrong, and I think it's distinguishable in that I think Mathis has shown, and I think Mathis was also sort of, you could see Mathis was sort of, Diacheneko was also sort of before Mathis. I think it shows that, that is wrong. I think when you are an emerging adult, I think those cases have said you are different, and since they're not covered by the regulations, then you are entitled to an expert. I would also say it's distinguishable because you have a unique circumstance here where someone committed their first offenses as a juvenile, and then they committed their last offense as an adult.
That's your unique circumstance? Why do you say that's a unique circumstance?
Well, the court, again, was not applying the juvenile factors, particularly, did not apply the factor, I don't remember the factor number, but did not apply the SOAR factor for juveniles to this case. And I think particularly in regards to factor 2, that's particularly evident, because factor 2 was, she applied the repetitive and compulsive behavior factor.
But before you even get there,
Okay.
right, you need to prove to the hearing examiner there's something unique about your client that would justify the allowance of a motion for expert funds. And later on, I understand
Yeah.
you're talking about how it impacted you,
Yes.
but the entitlement to expert funds. And I just don't see, counsel, how anyone who's 18, 19, 20, or 21 would be any different. I'm not suggesting it's not a bad idea, but if I were to adopt your theory,
Yeah.
then every 18, 19, 20, and 21-year-old would have unique circumstances because, right? They all have adolescent brains.
Well, I think this shows that there is a flaw in the regulations, that the regulations don't consider that. That is a problem as long as the regulations don't consider the uniqueness of emerging adults, that is a flaw in the regulations.
Can I ask a procedural question? I think I see what you're saying.
Yeah.
This is a person who committed their last sex offense as an emerging adult. Maybe they have a lower risk of reoffense than someone who was 29, or whatever. We know there's a brain development thing. So it's not a question of how old they are now. It's a question of predicting based on something that happened in the past. And maybe it's like, I don't know what experts are allowed for. I assume they're allowed for brain injury or low IQ maybe, or I don't know what else. But all the people in that bucket get, if they ask for it, presumably funds, because it's not addressed in the regulations. And it is also clear that since the court has, SJC has recognized this characteristic of emerging adults and their brain development, there's something different about this group, and the regulations have at least as yet not been updated in any way to reflect that that's a different category than juveniles or adults. So I understand why you would be asking for funds for an expert to talk about that. Justice Walsh says, can't everyone in that age group do it? And I also guess I think the answer is, at least right now, if you are, maybe they are. But at some point, someone should be bringing a facial challenge to these. I'm not saying you had to or that it precludes your argument for an expert. Someone should be bringing a facial challenge saying these regs don't account for this rather important factor. How would that happen? Does that happen in an ordinary SORB proceeding? Does some kind of declaratory judgment action or something have to be brought? Do you know how these are challenged when they're challenged on their face?
I don't know off the top of my, I don't know, Your Honor. I certainly can, provide a.
No, I mean, we can figure it out. Okay. But it seems to me that that second thing ought to happen at some point, yes, so that courts can figure out whether, in every case, this is something that ought to be addressed by a reg.
Yes, Your Honor.
Okay.
Well, turning back again to his unique, I've discussed his unique circumstances. I'll briefly say, just mirroring the SORB regulations for expert funds, which I apologize for not citing in my brief, but he identified an expert, and I would say he also provided significant documentation. He cited scholarly work that showed young minds were different. Well, the scholarly
work is useless, it seems to me. Scholarly work that says 16-and-a-half-year-olds or 17-year-olds like X or like Y may be a hint, but it's not as if there is, at least that you presented, scholarly work saying, in this context of reoffense, sexual offenders reoffending, being an emerging adult, maybe there is, but it doesn't seem to be in the record.
Well, that's exactly right, Your Honor, and that's why he needed an expert, because I think he presented enough scholarly work in his motion and at the hearing to sort of meet the bar of showing that an expert is required, but the hearing examiner's unguided analysis of this scholarly work certainly wouldn't be a substitute for an expert who is absolutely.
Did she explain how she took into account the emerging adulthood? Or she just said, I took it into account, I thought about it the whole time or something? Or
I think she says she does take his youth into account in his changes. I don't remember, let me see, Your Honor. She says she does take his youth into account, and I think, I don't have the exact quote for that, Your Honor.
How would she know how to take them into account without an expert telling her what the consequences of this fact is?
She wouldn't, Your Honor. That's exactly why an expert was needed, and the SJC has said that the same thing in one of their, in DOE 89230, where the expert engaged in unguided analysis considering Doe's schizophrenia. Because he was mentally ill, and again, that wasn't covered by the regulations, he was entitled to an expert, and the SJC reversed that case. And now, Your Honor, I'll just briefly say regarding Factor 2, again, that was applied with full force even though he committed that factor while he was a juvenile.
He was 13 at that time, right?
Yes.
All right. So in Doe 6729, the SJC talks about Dr. Hansen's research and says, while there's no predictive value for the risk of reoffending based solely on the commission of multiple sex offenses, there's value if the person gets caught and then goes on to reoffend. And then it says particularly when the criminal justice system doesn't inhibit them. So here we know, of course, he wasn't charged, and the adults all seem to have committed dereliction of duty because they promised he would get counseling and then nobody made sure he got counseling. But he was, the hearing examiner didn't apply the heightened weight. Like factor 2, either it just applies or it can get a heightened, and she just said it applies, right?
Yes, two things, Your Honor. First, I would cite Doe 136253, where that concerned the public place factor, and in that case, the court said that because you are applying this factor with full force to a juvenile, you had to explain why, because a juvenile was different, and that it's not intuitively obvious why it would apply with full weight to a juvenile. And I would also say, again, that you don't have to dwell on a factor, you just have to consider it. I think the case law says that it's sufficient to mention a factor in order for it to be an error and require remand.
All right, so your challenge with factor 2 is that the board is arguing that Doe waived this argument. So where can you show us in the record below that your client made this argument?
I see I'm out of time, Your Honor.
Answer the question.
Okay. Your Honor, I would say that the Doe challenged the substantial evidence at the Superior Court level, and I would also say that there's an issue of judicial economy here because Doe at some point is going to have another hearing. He's going to have another SORP hearing, and this will have to be flushed out whether this factor can apply with full weight or not.
Don't the regulations use factor 2 in that way even for juveniles?
Your Honor, I'm not sure off the top of my head, but I would say, again, he didn't get the benefit of having the juvenile regulation.
That's not my question. My question is, are they all the time in juvenile cases saying, oh yeah, you were caught by the police or whatever, someone talked to you or you were caught when you were a juvenile, and yet you repeated and we're going to use factor 2. Do you know? You don't know if that's used for juveniles?
I don't know, Your Honor, but I would just say that he didn't get the benefit of the juvenile factor applied here too, where normally if this had occurred when he was...
That's not your argument. Your argument is that we don't know how 13-year-olds respond to this kind of intervention, which maybe we don't. But if they're all the time applying it to increase the severity of whatever they're doing under the juvenile statute, I think it undermines the argument that, that this is not, has never been thought of.
Well, I think the issue here is he committed this offense when he was a juvenile, and he committed his subsequent offenses when he was an adult. So he's sort of in another world where he doesn't get the benefit of the SOR factor for juvenile, but at the same time, some of these events occurred when he was a juvenile, and again, he's being treated again as if he is an adult.
Okay. Thank you very much. I see no further questions. Excellent argument. We will hear now from Attorney Blackman.
Thank you, Your Honors. Jessica Blackman for the Sex Offender Registry Board. I will start with, since we ended on the factor 2 issue, I'll start there. I think what's important to note in these cases is that every factor takes into account a juvenile or an adult. So it delineates whether an offender is under the age of 18 or over the age of 18. With regards to factor, well, let me start over. The other important thing to note here is that Doe was not convicted of an offense as a juvenile. His only convictions were as an adult. So the only thing that brought him under the jurisdiction of the board were the 22 sex offense charges that he was.
I don't know what that has to do with Factor 2. Factor 2 is about having been caught between sex offenses.
Correct.
And the hearing examiner found that he was caught when the police were called and talked to him.
Absolutely.
And I take it the argument is, but he was 13. We don't know how a 13-year-old reacts to that kind of being caught, whether in fact their recidivism is as serious after being caught as an adult.
So, again, to go back to what's important to note is that all of the factors take into consideration whether they're juveniles and how that.
So you have
Goes
some
against
data on recidivism underlying the regs. You have data on recidivism by 13 or early teenagers who are caught, and that in fact that is the same. It has the same bearing on risk of recidivism as in adults.
No, what the board takes into consideration whether offenders are juveniles at the time of the offense or adults at the time.
How does Factor 2 do that?
Factor 2 specifically indicates, in all cases, whether an offender is caught, detected by somebody other than the victim.
So how does it distinguish juveniles from adults?
So with juveniles, the factor indicates that juveniles who continue to commit sex offenses after being detected for prior sexual misconduct still applies to those offenders.
So it doesn't apply differently at all?
It's correct. They apply in both situations, but they specifically delineate adult versus juveniles in all of the factors and how they apply.
So Doe argues here that a police interview is, that there's not enough intervention there to show compulsion when he then reoffends, particularly when nothing happened. He had this police interview and then nothing happened. So why would that, one could argue that gives the opposite message to the juvenile. Go right ahead.
Right.
Nothing's going to happen to you.
So the factor specifically indicates that detection includes being cautioned, warned, disciplined, criminally charged, or otherwise sanctioned by an adult authority, including police. It could be any adult, police, schools, teachers.
I know we have a second SORB case on. I don't know if you're arguing that case or if somebody else is, but
Not me.
isn't there a case that says you can't go with common sense in this area? We need to go with, in common beliefs about sex offenders, we need to go with scientific studies?
I'm sorry.
Isn't there a case that says that in this field, you need to use scientific data? We can't just go on our common sense or our gut instincts about what's going to make a sex offender more likely to reoffend?
I don't know of the case exactly. I think all of the regulations themselves are based on scientific and other, regulatory issues.
So here the hearing
And studies.
Here the hearing examiner, you say in your brief at page 36, the hearing examiner did not apply Factor 2 at full weight. The hearing examiner said Factor 2 applied, so I think you're saying there's an extra heightened.
There's a heightened where they've been convicted,
Prosecuted,
charged,
okay.
convicted, and then reoffend. So there used to be 3 levels. There's now
Yes, we're
2
very
because of
familiar with that.
the lower courts. So in this case where he was.
We have a published case where there was a confrontation by a police officer and, but no prosecution, and we held Factor 2 applied.
I don't have one exactly on point.
No, but there are many.
Many
published
cases.
Of cases in which mom, dad, somebody catches.
Teachers.
Right.
You don't
and-
cite any on page 39 of your brief when you say we being confronted by anyone is enough.
Just by the plain language of the regulations and that factor itself, I think is is clear that any type of detection other than prosecution is what would
because
raise
this
it.
is, again, it's going to come up in the later case, because in that later case, 3 different women fought the guy off, but I think Sorb's position still would be markedly, that's not a confrontation, because it's not good enough if the victim beats the guy off, right?
Anyone other than the victim is basically what is required. So I think here, where there's 2
Anyone
sets
other
of
than-
parents
okay.
and police involvement,
Well, that's why I'm back to my scientific data versus common sense, because I got to say it, my view, it might be enough if a woman beats some guy from, and keeps him from raping her. But we'll leave that for case number 5. You might want to give your colleague a heads up.
that's okay. I think,
Turning, though, to his age, and this is also an issue in both cases today, but in this one, the examiner says under factor 37, I do acknowledge the petitioner's youthfulness. And I'm trying to understand how we're supposed to review that. Like, I acknowledge it, and then they don't say, but I disregarded it, or I acknowledged it and it weighed heavily. Like, they just say they acknowledge it.
Well, I
How
think
do
what-
we review that? What do we do with that?
I think what she's indicating, and I had pulled that portion of the decision out, she says, I acknowledge his youthfulness at the time that he committed the governing offenses as well as the sexual misconduct. The sexual misconduct being the 13,
Yes.
at age 13. He was over the age of 18, but still, she's saying, given his youthfulness. What she then turns to is, given the time that he's been out of prison, which at this point was only a year, and showing that he's obtained employment and had stability as a reflection of his maturity and improved decision-making capacity based on him being a youthful offender.
Why
or
wasn't he
younger.
entitled to an expert on brain development?
Because at the time he committed the index offense, which brought him before the board, he was 18 years old.
Okay, but I
At
don't
age-
see how that's his point, right? His point is that I was 18 or 19 when I did this.
An
We now
adult.
have some SJC decisions that change the criminal law
Correct.
so that there's no longer life without possibility of parole for people in that category because they are in some way less culpable. Now, you guys haven't amended the regulations to either say, yes, but there's no data that shows that that does anything for us, or yes, and there is data, and therefore we are counting, it should be dealt with like this. So it's not taken account of in the regulations. But we know from SJC decisions that this is a different category than all adults. So simply saying he's an adult doesn't get us all the way home. His argument is yes, but your regulations treat 18-year-olds the same. The SJC has at least has held that they're different enough that they face different criminal punishments. So why isn't he entitled to an expert to examine him and determine whether this is something that makes a difference in his case or doesn't?
I think, to begin, the important part in the Mathis case is that it very, very specifically addressed only offenders who were between the ages of 18 and 20 in the criminal court setting, specifically regarding those very small portion of those offenders that were convicted of
Look, I don't know
first-degree
what that
murder.
means. He was between 18 and 20.
Correct, but
And he committed a crime in the criminal justice system. And one of the consequences of that in his case is he has to register as a sex offender at some level.
correct.
So why doesn't it have some bearing on this question?
Because the court in the Mathis case stopped at those offenders within the criminal justice system that were convicted of first-degree murder and got sentences of life without parole.
And they were less...
And they stopped
No, go
there.
ahead, I'm sorry.
So that has some connectivity to what SORB does, in the sense that if anyone has been in the company of or has experienced raising an 18 or 21-year-old, you don't need an expert to say they're impulsive, they're risk-taking, and you hope and pray that they outgrow this behavior at some point in time, and generally they do, right? And so there's a lot of bodies of studies now And because scientists tapped into the brain to say, hey, what every mom and dad and everybody else figured about when they were 18 to 21, it's because, right, those neurons aren't connected. I don't need an expert to say that this particular sex offender didn't have all the connections, because all 18 to 21-year-olds, to some degree, don't show good judgment, right? Your bigger issue, and I think what the panel is hinting at, is factor 2, which unfortunately was not challenged in the Superior Court facially, right? It's that you weigh in, when you're deciding risk, and you're deciding whether it's reduced or whether it's enhanced, you have not addressed or factored in 18 to 21-year-olds. You say they're riskier because they committed these crimes and they continued to do it, right? And they're compulsive and it's repetitive. You have not factored in a specific body of science. And so, if the challenge was factor 2 is facially unconstitutional because it doesn't, I think that one's, as my colleague has said, that's a tough rock for you to lift up over Sorb's head, but have at it. But
Well, I think-
here, it's expert funds on this very narrow issue. But
The purpose, I think the more specific issue is the purpose of allowing for expert funds is to address an issue where the hearing examiner may lack the knowledge regarding that very specific issue related to that offender. And in this case, the factors address very specifically adults versus juveniles.
I'm sorry you
how
keep
those
saying
affect-
that, but Justice Walsh said people between 18 and 21 are different. You're saying, look, it's an adult, so I don't care that they're different. And the whole point is, shouldn't you care that they're different? And don't you need to know how they're different? And so shouldn't there be an expert to come in and tell you how they're different?
I don't think that it requires an expert in these cases for the
Do you
hearing
let
examiner to come to that
experts come in when
conclusion.
someone has very low IQ? What do you grant expert funds for?
Where there's a condition, a mental abnormality. So in this
A
case,
mental abnormality. So even though that person's an adult, every time one shows up who has a mental abnormality of whatever kind, they get an expert. And I think all Justice Walsh was suggesting is this entire group, 18 to 20, may have, I wouldn't call it abnormal, but a different, mental status than older people.
and that may be the case, but in this specific instance, it was not required. The hearing examiner considered his youthfulness, considered the fact that he was emerging adult when he committed the offenses. That was impacted in her decision. She acknowledged the articles that he submitted. She acknowledged the fact that he was a juvenile at the first time of offense, which he was not convicted of. She acknowledged that he's been incarcerated, been released, and made better for himself, took all of that into consideration, the fact that he was an emerging adult at the time, and used that information to then lower him from a level 3 to a level 2. He also did not raise this issue when he was classified as a level 3, when it was even closer in time to him actually committing the offenses. So he was...
What do you mean didn't raise it? Didn't he ask for funds?
He had a hearing, but this was his second time before the board. So he was classified as a level 3 in 2011.
Yeah?
This was
Before
a-
Mathis.
And,
Before the kids
but even
saw
in
about emerging
Mathis,
adult, how would they have known?
but Mathis didn't,
It did.
it didn't change the law. It didn't
Oh, it
validate.
changed the law, it just hasn't changed the sex offender registry board factor 2, but I'll leave it at that.
Do you have?
Just back on the Factor 2 issue for a minute, the board cited Doe 136253 to argue that case applied full force to a juvenile, that you have to explain why. I have to say I don't have that on my iPad, so do you have any response on that case?
I didn't hear the first part of the,
He is relying on Doe 136253 in his argument today to say the hearing examiner has to, I'm just telling you what he said the case said, that the hearing examiner has to explain why they're applying Factor 2 with full force to a juvenile. And I'm wondering if you, I don't know whether he cited this case in his brief or not, but I'm wondering if you have a response.
so first, Doe was not a juvenile when he committed the offenses for which he was convicted of, so which
got that.
brought him before the board. So the factors themselves do not apply to him as a juvenile. The factors apply only the adult-based factors. So while every factor includes how it applies to adults versus juveniles and women versus men, he was not a juvenile when he committed the index offenses which brought him before the
I think
board.
what we're really wrestling with is there's a lot of language in Mathis. So first of all, the point of Mathis is, do you condemn someone for their entire adult life for decisions that may have been driven by an emerging adult brain? And on some level, that translates neatly to the SORB situation, and much of the language in Mathis seems to apply. Like in that case, all four experts agreed that compared to older adults, emerging adults are more impulsive, more concerned with their immediate circumstances, and less able to envision future consequences. And so, can you tell us that scientifically the current regulations account for that?
Not specifically.
Thank you.
But I think, again, it's important to note that these were adult offenses for an adult offender who was convicted as an adult.
We understand that.
Okay.
All right, thank you very much. I see no further questions. Very good argument by each of you. The case is submitted. The next matter we will hear is number 24324. It is partially impounded, so I'm not going to say the name of the person, although I don't know if that's what's impounded or not. I'm just going to say in the matter of an individual, and I believe we will hear first from Attorney Lose.
Members of the panel, may it please the court. My name is Attorney Loss, and I represent the appellant Michael Improvio. My pronouns are he and him. Your Honors, this appeal is about
Could you, excuse me, could you slow down a little bit?
Okay.
And could you bring the microphone toward you a little? Thank you.
This appeal is about whether or not the appellant is an interested party to Frank Pedro. Frank is the brother-in-law of the appellant, Michael Improvio. Their relationship began
Can I
in
ask you a question? So we're familiar with the facts.
Okay.
And I just want to make sure on your legal argument, is your claim to interested party that provision in KVG or BVG?
BVG, yes.
BVG. Got it right. All right. About the love and care that Michaelin
Yes.
has shown. That there's no contest here. You're not contesting that she fits within the enumerated heirs, spouses, but all that. She doesn't, right?
She does.
Wait, so it's both?
She does fit in, she is an interested person under BVG, and she is also a person interested in the well-being of him. She qualifies under both.
Interested in the well-being isn't in the list.
Right. So
The list is about financial interests primarily.
So I just want to make sure, it seems to me, from reading the statute and the case law, that the statute provides a laundry list of individuals who are considered interested parties such that they can object, okay?
Yes.
And it seemed as if, but I want to make sure that I'm clear with your argument, you weren't arguing that she fit within the blood relative, husband or wife, et cetera. Your position was that she is an interested party because under BVG, the court said, well, it's not just these people in the statute, in this language. There's also another category like BVG, the grandfather, granddaughter.
Exactly, I understand your honor.
Okay.
What you're
So
asking.
So is your claim under that second piece, which is that she's an interested party because of her love and care and concern for Frank?
Yes,
And-
that's-
And nothing about the heir's blood relative financial state?
Kind of a little bit of both, because she actually was the power of attorney and the healthcare proxy for Frank for many years. She was actually named as his personal representative in the will and the
But when
trust.
she objected, she didn't have any of those rights, right? She wasn't no longer a healthcare proxy or a power of attorney or any of that,
No,
right?
she was no longer at that point. It was just based on her love relationship with him.
Okay, so it's the love and care of Frank
Yes.
that you're claiming she's an interested party. Thank you for clarifying. Please continue.
You're welcome. Let's see. In his pleadings, Hawthorne refers to Michael Lynn as a morally bankrupt person, as well as an unrepentant grifter. He has also claimed that Michael Lynn tricked Frank out of his home, and recently stated the only difference between Frank's daughter Laura and Michael Lynn was the amount of money stolen. And
Is there any thing in the record that explains, I know it was a default judgment, is there anything in the record that explains the transfer of the house or the moving of the money that was ultimately reversed?
Yes, there is an affidavit from attorney Stephen Saber that Frank was actually going to do a will and Medicaid planning. Attorney Saber doesn't actually do Medicaid planning, so he was referred to attorney Bruce Haig, who is a local expert down there on doing it. And there are affidavits in the record as well from attorney Haig and another attorney in his office that this was all done by Frank at Frank's will. The main issue here is that there's a sister-in-law, another sister-in-law of Frank named Margaret Avila. And if you go through Luann Puel's affidavit, this whole case and my brother's whole argument it repeats that actual affidavit as if it's fact. The affidavits of Case, Haig, and Saber debunk that completely. I
And
mean,
do they say, although of course I'll look at them,
Yes, thank you.
do they say that this property was transferred in an attempt to avoid having it taken by Mass Health after her death, which we know happens in many cases, but also there are planning mechanisms, although I have to admit, I don't understand what works and what doesn't work and what's okay and what's a look back and what's not, but that this was an attempt to protect those assets for his heirs or devises.
Yes. Again, Your Honor, Frank is and has always been a very thrifty individual, and he wants to make sure that none of his money gets wasted. So that's why he wanted to protect these assets for that particular purpose. The way that Medicaid planning and nursing home planning works is that there's a 5-year look-back period when there's a transfer that was done, and these transfers were done in February of 19. So last year, all of Frank's assets would have been protected from a nursing home lien had this not been redone.
But if his Medicare, or Mass Health, whatever it is, support began before that, these would have been prohibited transactions, and Mass Health could have gone after the assets anyway, is that right?
Not necessarily true. There is a letter from Attorney Haig, or a couple of letters from Attorney Haig, explaining to Attorney Hawthorne the mechanisms upon this, and there was kind of a butting of heads between Hawthorne and Haig, that at one point Haig said to Hawthorne, "You obviously don't understand how my type of trusts work. You don't have an understanding of that." And at that point, It's my belief that Attorney Hawthorne pretty much crossed Hague off the list.
This is all in the record?
This is all in the record, Your Honor. It's-
So I read that, and let me just back up for a moment. And there's a lot going on in this case, but the issue before the court is whether or not your client is an interested party under the statute in order to object. And I have to be, there's some skepticism when I read an attorney who's representing both the beneficiary, who's bringing in the person who has already been determined now to have late onset Alzheimer's and dementia into an office, and representing both and creating an instrument, whether or not that prevents Mass Health from getting their assets or not, I don't know, and I don't even think it's important to, the question is, you claim, I didn't see a standard of review in your brief. What's the standard of review that we should be looking at when determining if the judge erred in determining that your client didn't have standing?
Okay. With regard to the standing, there is not a need of standing for an interested person. An interested person, even a stranger, can actually come in. Somebody with just pure humanitarian desires can come in and actually file petitions, file things on
So
behalf.
call it something different,
to-
maybe less broad than standing as in jurisdiction, right? But the person has a right to go in. What is the standard of review when the judge said, your client does not have the right to come in and object? Because you would agree with me, right? If I was down the road neighbor and said, oh, Mr. Pedro, he's always a nice guy, I don't think his sale of real estate should happen, I wouldn't be able to object, correct?
Exactly.
But your client, you claim, has this long, loving relationship. What's the standard of review? And secondly, what's the evidence that the judge somehow erred when applying that?
Okay. The judge did not. He accepted the default judgment as a fact. The facts put into the default judgment.
So I looked at the docket. There was a motion for summary judgment. That was not answered, and the judge allowed the motion for summary judgment. Now, on top of it, you didn't file an answer, and I understand some of the reasons why you didn't.
Okay.
Legitimate reasons why you were trying to resolve the case, but you still didn't file an answer.
But,
But the judge found and allowed the motion for summary judgment. And under the rules of summary judgment, when there's an unopposed motion for summary judgment, the findings of fact are that. All of the facts in the complaint are taken as true.
Okay.
So there I read the equity complaint, true, 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 true.
Okay.
Why can't the judge rely upon the factual findings in a judgment when he allowed the motion for summary judgment?
Your Honor, first of all, this was during COVID-19. There were tolling orders. Judge Smola, who was the judge that signed the actual default thing.
That's not the appeal before us.
Okay, well, okay, understanding that.
Not the appeal before us. So
Okay.
focus your argument on the appeal before us.
Okay, well, I was just trying to answer
I-
questions.
yeah.
Secondarily, that case is not in appeal. It's still pending before the court. The problem is that that case, like you said, has gone to judgment. It actually has not gone to judgment. There were appeals and a motion to remove the default, but it's still pending with that actual court.
Oh, was that stayed pending this? I don't understand. Why are they not?
Because there was an agreement in August of 2020 to actually settle everything. Attorney Kane drafted that agreement.
Is
and
this
in
the
terms of that
stipulation?
agreement-
Is
Excuse
this
me?
the so-called stipulation or something else?
So-called stipulation,
Okay.
drafted that, and the
Yeah, but
terms
the
of
judge said that was no good. This judge said that's no good.
Understood. The terms of that stipulation stated that the withdrawal of all of the motions regarding the removal of the default, once that was allowed, then the stipulation would be filed with the court. That has never been allowed.
But
There's
the
actually-
judgment entered, okay?
Yeah.
So the judgment entered. That's why, in the
And there is-
conservator case, the judge was having a field day and was, frankly, on the record, annoyed because the two of you are trying to decide about the equity case, and the judge is telling you, the equity case was way back when. That ship has already sailed. Judgment entered. You can agree till the cows come home about how that case is going to be resolved. It's done. So the disagreement about whether Brian Avila is going to be the guardian or not, we don't have agreement. We can't fix this, but it doesn't negate the fact that the judge entered summary judgment and all the facts in the complaint are assumed to be true. In those facts in the equity complaint say your client wasn't the loving, caring person. Why can't the judge rely upon that is my question.
Again, Your Honor, that equity case is not at final judgment. There were timely motions to remove that default that were filed, and there is a note in the record appendix from the court
You're saying there's not a judgment on summary judgment
there is
in the
not a
equity
judgment
case.
on that. It is still under review, and those motions need to be
All right, and
marked
then-
up. I have
so
not marked them.
Is Judge Cronin the judge that was in this case?
That was Judge Peter Smoller was in the equity case at first.
Right, but I'm asking about Judge Cronin, that's this case.
He only heard that on February 19th, 2021, in the transcript, where he seemed to be confused, and he said that it did go to judgment, and we weren't hearing that day.
But they argue, or he's about to get up and argue, that Judge Cronin said that as to the stipulation, the only dispute was regarding the conservatorship appointment, but that what your client agreed to was not in dispute. And he made findings about that, so, and he provided record citations that when I looked at, seemed to bear up. So why is he wrong?
With regards to the references that he made, is this based off the equity?
The only part of the stipulation they were truly fighting about was who was going to be appointed as the conservator, not that your client was getting a certain amount of money and giving up other rights.
Again, based on the terms of that stipulation, paragraph 4, the stipulation was not to be filed and should not even be filed.
Did your client get the 31 grand?
Yes, she did get the $31,000. But again, there was a separate stipulation from Attorney Hawthorne at Bank 5 that actually Attorney Hawthorne said, we don't need to abide by the stipulation, we'll just do one at Bank 5, which is actually in the record appendix as well.
And where is that in the record appendix?
I don't know off the top of my head where it is, but I could send a letter into the court providing the exact location of that.
You've read the case law that talks about when a stipulation is filed with the court, that it doesn't automatically disintegrate. It needs judicial action.
Yes, and there was judicial help.
How do you differentiate? Did your client ever object? So, for example, Brian Avila objected. When that stipulation was going through, he said, wait a minute, Judge, I don't want to be guardian anymore, and the judge halted on the guardian position. But did your client ever make a motion with the court? Because I looked through the record and I didn't see it, but maybe I missed it, to say, Judge, that stipulation that I signed and dated, I need to be heard on this because it's not valid.
Okay. Again, Your Honor, that stipulation should not have been filed with the court.
No, but did you ever do anything?
By its own term. And during that hearing, Judge Cronin 10 times approximately said there is no agreement, there is no agreement at all on this, and actually scheduled the matter for
Right,
trial.
guardian. There was no. There
We
was not an
redid the
agreement.
stipulation, excuse me, sorry.
Did you file something to say, and by the way, my client also wants to back out of the stipulation?
We did. We filed a subsequent stipulation that replaced the previous one that actually nominated Attorney Hawthorne as the conservator, and on the guardianship case, nominated Family Services. We went back and forth on that for the week between the two, and I wanted in that document language that Attorney Hawthorne would provide, that my client would continue to be an interested person, and so on. All of the things.
And that happened? You got that stipulation?
He assured us, Attorney Hawthorne assured us, because he was bonded and he was very experienced in doing this, that he would always provide documentation.
That in the record?
Yes, it is in the record.
Is
There
that the
are-
site you're going to provide us, or do you know that site?
It's in a bunch of emails between Mary Kate Connolly, myself, and him, where basically, I think there was either 5 or 7 emails where we kept asking him, when are you going to provide this? Are you going to provide it? And he would always respond, it's at the top of my list, and so on and so on and so on. And I later learned, looking at the file, that these things were provided to me months after they were provided to Brian Avila's attorney, and months after other things. It almost seemed like he wanted to keep us.
Okay, well, we got to keep focused on what the legal issues are in this case. So this is a 7-volume record, at least 8-volume record. So I, for one, would like to have the citation for what you think is the document that's the key to this, because I'm not hearing it from you. But we have some different housekeeping measures as well. So they've filed a motion to file a supplemental appendix. You've opposed that. If I understand you correctly, you want to file a supplemental appendix that includes everything the appellee proposes, but you want to add in some additional pleadings. Is that right?
Exactly, Your Honor. My brother here asked to file a supplemental appendix to include the docket for the equity matter. Some of it is included as exhibits in what you already have. And my objection was not to what he is filing. It's just he only filed the portion of the equity complaint that supports his argument, which is his right. I wanted the entire record to be shown.
But you're wanting to put in everything he said he's putting in.
As well as
Okay.
I think there's 17 or 23 responsive pleadings that were done after that
Okay, I think.
motion for default.
We're past time, so I got to just keep us very focused.
I apologize for that, Your Honor.
You argue on page 10 of your brief in footnote 2 that it's apparent that the docket in Judge Cronin's review of your client's opposition did not include the 105 pages of certain exhibits A through GG. What I'm wondering is, did you file a motion to reconsider, or have you gotten the judge to say whether the judge, because we have no basis, I mean, if it's in the docket, as far as we're concerned, the judge considered it. So I don't know what to do.
Well,
You say it's apparent, but no, it's in fact the opposite, unless you've done something.
Okay. The Bristol County Probate Court, the clerk's office, had 53 errors in its docket sheet. Most of the errors involved only scanning the first page of documents, not scanning the second page, only having the first page of this document, not including exhibits or any other attachments to it. The second major issue was that 13 times they mixed up Michael Profio with her husband Richard, so much so that the appeals court thought Richard was the appellant and not
And he's not here.
and not Michael Lynn, you know. So the issues that the court did, the other thing that the court did, the assistant registrar is she actually blocked me from actually either viewing the file and even being corresponded with on the file. And because of this, I didn't even get a copy of the judgments when they were issued. They didn't mail them to me. I found out from my sister.
What is your client a party to that would entitle you to get these things?
We appeared before the judge on a hearing. There was a motion for sanctions against me and my client, and there was this is prior to the decisions that the judge issued. There was decisions affecting us, so I think, Your Honor, we would be entitled to a decision from that, and I had to.
Can I ask you, I don't know if do you have more?
Good.
All right, so we are way over time.
I understand.
You say something about it's not your fault, it's our fault. You say something about the relationship between counsel for the ward here and the conservator, is that right, or the conservator's lawyer?
And I can summarize that. Bristol elders got involved at the request of Margaret Avila, who basically was the individual that made all these accusations and that basically was repeated into my brother's equity complaint. Based off of that, and I've lost my train of
It's just about what the relationship is between the lawyer for the ward.
I have it, Your Honor, sorry about that. Bristol Elders' attorney, who actually brought the action, Mary Kate Connolly, actually, there's an email I believe it's January of 2021, it's in my notes, where she refers to Michael Lynn as a unicorn, and also that she said, "It is my opinion, and I stand by my opinion, that Brian and Margaret Avila have poisoned," have...
I'm asking about the lawyer for the ward.
No, this is the lawyer at Bristol Elders that actually...
I'm asking if there's a relationship between the lawyer for the ward...
Yes.
...and anyone, the conservator or the conservator's counsel.
The only relationship that I see between Attorney Kane and Attorney Hawthorne is that Attorney Hawthorne misled my client by stating that there was an agreement of the court that Attorney Kane should continue
I see.
to be his counsel.
All right. Your time has expired. That is our fault. Thank you very much, because it's a complicated case, and you've provided us with a lot of useful information.
Would you want a post-argument letter? I would be more than pleased to...
For the citations, do you want that? Citations only that anyone on the panel asked you about. Thank you.
And the citations were? Oh, okay.
You're
Thank you.
saying there was a subsequent stipulation that replaced the earlier stipulation?
Thank you.
Okay.
Thank you, Your
We
Honor.
will hear now, thank you. We will hear now from Attorney Stiles.
Thank you, Your Honors, and may it please the Court. I'm Ethan Stiles, and I appear on behalf of the conservator, J. Marlon Hawthorne, for the protected person in this case, Mr. Frank Pedro. My brother has spent many pages and volumes of appendices to try and gaslight the court into believing an alternative reality.
All right, before we get to that, can we just do the housekeeping? Because we don't, this case is such a mess, we don't even have the right record before us. So you want to file a supplemental appendix, and he says no, but then he says he'll file everything you want to file, but he wants to file some more stuff. What's your position on his, do you agree he's willing to file everything you want?
Yes, I only filed what I thought was relevant to what...
Right, but do you oppose his motion, or are you good with his motion?
I'm fine with this motion.
Thank you.
Anyway, so in this, yes, in this alternative reality where Michael and Profio somehow is an interested party or has standing to participate in these proceedings, but she does not. She has no rights to be heard. She has no right to file pleadings, objections, motions.
Why not?
Because the court has ruled that she is not an interested person.
Okay, so I look at the interested person provision, and at the end it says the meaning, as it relates to particular persons, may vary from time to time, and shall be determined according to the particular purposes of and matter involved in any proceeding. The judge said, if someone were truly interested in the welfare of, didn't quite say this, but I take it the point was, if someone is truly interested in the welfare of the ward, they can come in as an interested party, but Ms. Profio is not in that category because of the default judgment and the stipulation.
That's correct.
Okay. The default judgment never litigated the question of wrongdoing by Ms. Profio because it was a default judgment.
Nonetheless, we take the fact, the default judgment refers to the complaint filed, the equity complaint, and we take those facts as determinative of what the liability or the consequences or what actually happened was, and what happened as reflected in the default judgment.
I don't see why we do that. I mean, I hear what you're saying, but I don't see why we do that. This is a proceeding to determine what happens with this ward's property, and he says anyone who cares for their welfare can come in. Shouldn't he hold a hearing to find out whether that's really what happened?
Well,
because my sense is that there's at least an argument. Maybe I have to read through all these lawyer letters from Hague that opposing counsel refers to. But if there's some question about whether maybe she was trying to protect his assets for his heirs and devises, then it's not quite the nefarious story that the opposing party asserted.
Well, I believe that between the stipulation and the default judgment, those questions have been foreclosed.
Okay, the stipulation doesn't say she's a bad person. It just says I won't appear again in the case. And I agree that if that were binding, then that might be an issue. I also see this very judge who relies on it saying at a prior hearing where they tried to get the court to accept the stipulation, the judge says repeatedly, there is no stipulation. There is no agreement. Same judge. And now the judge says, oh, there's a stipulation. I don't see why there is no stipulation, there is no agreement, and failure to allow it to be entered by the court as a judgment, why that doesn't weaken your argument.
Well, I have to put the judge's remarks into context. The hearing that's been cited to was a short status hearing. It was not a decision, not a hearing when he made any rulings or any judgments. The import of that hearing was, you parties, you have a dispute over whether Attorney Hawthorne is going to be the conservator. It's between the guardian and the conservators. Those are the only two parties who were having any trouble with this stipulation, and the judge said to them, either you guys resolve it yourself or I'm going to resolve it at trial. And within 2 weeks, they had a new stipulation, and it was resolved.
And do you know what the site is for that?
Yes, it is in, yes. The stipulation papers will be, I have them in my addendum to my brief. You'll find them there. I don't have the page number, but I did put the papers that I thought were prominent in the addendum.
Okay, let me ask you a question. Whether you call the equity a default judgment because the complaint was not answered to, or the motion for summary judgment, which is allowed, what Justice Rubin, I think, has said that I'd like you to develop a little bit longer is, ought the judge not have had a hearing and taken facts, him or herself, to determine whether this individual qualified as an interested person? So you can cite the cases that talk about default judgments. You get into a fender bender, nobody answers, judgment enters for the plaintiff. You can assume there was a rear ender. Now, the issue of damages requires a hearing, okay? But the facts, the liability, and you're assuming, you're understandably paralleling those cases and saying the facts in my equity complaint have now been accepted, proven, whatever. Okay. But now let me follow this up. There's support in the law for that. But for the position of an interested person, let's just assume that his client did all those things with a nefarious intent at that time. But today, she's a changed person. She actually cares for him, for Frank. She actually has his best interests at heart. And the judge has to make a determination today whether she can intervene and say, oh, hold up, I'm not getting anything. I'm not a blood relative, and I was a jerk before, but now I really care for him, and I only want his best interest. Now, certainly, the judge has discretion to decide whether the past outweighs the present, but could you envision a situation where today, that person actually has feelings and pure heart? And there was no hearing here. There was no opportunity for Michaelin to say, no, this is only because I'm concerned people aren't doing the right thing. We don't have that. What we have is she cannot be an interested party because she doesn't have his welfare because these facts were established. End of story. Doesn't he have a right to a hearing? Or doesn't she have a right to a hearing to establish that she can come in as an objector?
I believe that she waived that right in her stipulation. And also, the judge pointed out that nothing, that was in 2020 when the stipulation happened, when they actually withdrew all their objections, their motions, their appearances. There are actually filed papers in my addendum that say that we withdraw around that same time. So essentially, and that goes to his argument that the equity doctrine is somehow open. It is not.
See, my concern is this. I don't want to hide the ball.
Yeah.
The judge says none of the arguments in what she's filed go to the question of selling the house anyway. Do you remember that from the judge's opinion? That's wrong. It is quite clear, and I understand that, like many of these filings, you got to go through an awful lot of stuff that is not strictly relevant before you get to it. But she says exactly what the GAL said. How can we know this is in the best interests of the ward without knowing what his assets were, where they've gone, how much is being spent each year on him, and why, and what's going to happen to the cash that comes from the sale? That doesn't strike me as an unreasonable argument at all. She may not be an interested party, or she may, but that argument doesn't seem crazy to me. So I'm just concerned that the consequence of all of this is that doesn't really get before the judge. We have no opinion, right? The license issues, there's no opinion saying why it's in the best, I find it's in the best interest, check. And the only party, it seems to me, aside from the GAL, who is not a party, the only party who has made an objection on that ground is Ms. Profio.
Which she has no right to do. And I would also point out that Mr. Pedro is not, alone and only has the conservator who can dictate who his best interest. He has the judge, the guardian ad litem, his personal attorney.
Well, the guardian ad litem said, let's not do this.
And the judge heard that, and he disregarded that opinion, as he has a right to do. And he also has his brother-in-laws that also can speak. So it's not like Mr. Pedro is left at the mercy of the conservator's whim here. But getting back to Justice Walsh's point, essentially, when we come from the stipulation in 2020 to the hearings in 2023 on this issue of standing, the judge pointed out that in the stipulation, the stipulation ends by saying Frank Pedro wants no contact with these people. And in 2023, the attorneys represented to him, that's still the case. They've had no contact. They have no current relationship with them.
I thought he wasn't competent.
I'm sorry?
I thought he wasn't competent. How do we figure out what he wants if he's incompetent? Why does he have a guardian if he can assert all these things?
I mean, he is able to speak through multiple people, including the guardian and including his own attorney, his personal attorney, Veronica Kane, who joined our brief and speaks as well now as to his interest as then. And so ultimately, yes, this is not a case of BVG where there's a mutual relationship that's being obstructed only because of the views of one person. He thinks that they're grifters who stole his house from him. Why should he want any further?
Where's the factual finding on that? Shouldn't there be a hearing?
That's what his attorney represented. I mean, that's why we appoint them for that. We do have it, from the affidavit of the PSW also includes his own words that he was most upset after learning that his house had been taken from him, and that his brother-in-law tried to insinuate that his property really wasn't his because it was inherited through his wife and the sister-in-law's Ms. Profrio. So ultimately, yes, we do have, words from him in there that says that I don't want any part of these people. These people are wasting my money.
Well, but his argument is, look, if you'd have just left it as it was, we'd now currently, because it sounds like Frank is still alive, we'd be past the Medicaid look-back period, and the house would have been preserved for somebody, not Medicaid. But you went in and messed that all up.
Well, that's wishful thinking, I think, on the part, because now that complicated transfer, which even Attorney Haig said he wasn't sure whether Frank Pedro understood, what happened in 2019. And while it's all well and great to say in 2024, well, he got past the 5-year point, therefore the transfer is valid. What about those 5 years in between? From asking a 79-year-old man, hey, you can't go to a nursing home, you've got to wait 5 years because you gave your house to your sister-in-law.
But what you do is you look at the cost of a nursing home in Massachusetts for 5 years, and you make sure there's that much money so that you'll survive the Medicaid look-back period. And at least according to what I've read, there was that much money, and he would have survived. I mean, that's a rational plan. And if he's not competent, it's still rational for somebody to do that.
Well, to that,
what's happening right now? I mean, because one thing I'm not hearing is. I don't know whether this is true or not, but he's arguing that, and I don't mean any offense, and this is complicated, and they've certainly driven up your fees, no question, but he's saying the court found that you and the conservator were charging too much money, and I don't see any response to that.
That is,
Did the court find that you charged too much money?
I believe it did set our fees according, but that was only in the context of what he owed.
We do that. You know, I'm not casting aspersions. We do sometimes say that was too much. And that happened here. But so who's making sure that, you know, you're not charging too much money if it's not her?
Well, I mean, ultimately, it is the responsibility of the people who have an interest to make that claim. And, you know, that issue, that we didn't appeal that issue.
Who are those people? Who has an interest?
I mean, who has an interest in this present case? It would be the conservator, the brothers-in-law.
Well, the conservator is said to have overcharged also, so let's find someone else to supervise the conservator.
His personal attorney and the guardians ad litem, the judge, his brothers-in-law, anyone but not Michael and Profio, because she waived.
Does he have heirs at law?
He does have a daughter, yes. However, he disowned her. She's not in any of his wills, and she's.
He has a valid will, or valid as so far as you know?
Yes, he's had multiple ones. The last.
And when was the last one done?
The last one I think was done probably in 2020, or after he. It was the one that left his stuff to the brothers, because there was a will that left it to Michael.
There's going to be another fight over that later after he passes, I assume.
Undoubtedly, because as this case shows, that, you know, when it comes to these things, their word and their actions mean nothing.
So, I mean, you're relying on this judgment at Record Appendix 2-166, but that judgment says the defendant did not defend the action. So can a default judgment basically have a collateral effect?
Yeah, I'm sorry, Justice Harry, I didn't quite get your question.
You're relying on something, a judgment, an order that's in the Record Appendix, and the first line of which is the defendant having not defended this action. So I'm asking if that can have a collateral effect. Can it be used basically as you're trying to use it for claim preclusion or issue preclusion or res judicata?
Yes, I believe it's so, because ultimately that was, if nothing else, a condemnation of these people's behavior and conduct in this case. And we've seen nothing in the meantime to suggest that they've somehow atoned for their practices. So ultimately, that was another probate court issue. They had an opportunity to defend. They did not. They squandered it. They never actually filed an opposition despite
So you think they are precluded from litigating the facts based on a default judgment in any other proceeding? They're the defendants, and you think they can't litigate the facts in any other court suit for eternity?
No, as I think Justice Walsh said, that ship has sailed. That's done.
So you think there's issue preclusion on things that were not litigated on their merits? I understand there might be, well, res judicata is also a little weird because you're the plaintiff or someone, I don't remember who the plaintiff is. But you think the facts are precluded from future litigation?
That would be how res judicata or collateral estoppel work, generally, yes. And I would think in this case, the same court, the same parties, and issues to the core of the relation of the interested party proceedings, whether these people have a moral right to intervene. Okay. I think we have to look at that and consider it appropriately. Thank you.
I think we have both of your arguments. Thank you very much. The case is submitted. The next case we will hear is number 24310. This is McDonough versus PAUDEL.
Good morning.
And we will hear first from Attorney Bruce.
Good morning. May it please the court. I would be remiss if I did not acknowledge that 10 days ago, the SJC issued a decision in a case of Luppold versus Hanlon, which addressed the very model jury instructions that are at issue in this case. I'm aware of the practical implications of the SJC's decision upon the court in my argument today, but I do need to point out that this case is different in one crucial respect than the Luppold case.
Before we get quite to that, the plaintiff is saying that at no point you've just waived this issue, basically, that at no point in time did you complain about this had an impact language. So what do you, so before you even get to the SJC, what do you say to the idea that it's just waived?
I say context matters. It's an accurate statement, Your Honor. I didn't object prior to the jury instructions about the impact language. The two sentences at issue became part of the case when the jury came back with their question after
Right, but
several
he's saying
hours.
you didn't object then either, that you were satisfied with the supplemental instruction.
Again, Your Honor, context. If you read the transcript of the colloquy or discussion with the court after the jury question came back, which is, I believe, Record Appendix 4, pages 205, 206, my initial response to the court was, essentially, this is why I requested the standard but-for causation instructions and asked the court to repeat that. The court was not going to do that. It already declined that request at after the charge conference. The conversation then went on to what the court might say. And what the trial court proposed was giving an analogy of something comparable, which included a wrong site surgery performed by a dentist. The reason for the wrong site was the insurance paperwork said right side when the procedure should have been done on the left side. And I thought that that was an inappropriate example. So given the fact that the court had declined, again, to give the standard traditional but-for jury instructions, I did agree the court should not give that analogy or say anything more.
So, but I'm confused. I'm looking at Record Appendix 4 at pages 205 to 206, and I see the jury's question, and then I see a handwritten direction of, I guess, what the judge is going to say. But what I don't know is whether you objected to that.
Well, I apologize if I've given you the wrong site. Okay, I don't have the record appendix with me. I can go back and get you the exact page and send a copy of the page if you would like.
So do you think you waived this issue?
I don't think I waived the issue.
And you think that's because at this particular, do we have the transcript? I assume we have the transcript.
It's in the record appendix.
Okay, so you're saying that in that transcript, when we get to the judge's clarification, you're going to have flagged the had an impact language?
I think that's wrong. I think at that point in the transcript, I don't know if you were counsel or somebody else, counsel for Dr. PAUDEL says, I think they're confused, thinking that impact means something different than but for causation. Isn't that what's said? That is, that Dr. PAUDEL's position was they're the same, not, oh my gosh, they're different. Could you undo that by saying ignore the impact language or something?
I was trial counsel, Your Honor.
Okay.
Okay. I don't recall saying that.
I mean, we'll look at the transcript and see what the words are. I remember after reading it, and it's been a few days, but after reading that part of the transcript, I remember thinking, oh, that basically sort of agrees with the reading of it that the opposing side is making, that it's really about impact amounts to, or is intended at least to amount to, but for causation. I mean, you know, when I read the instruction originally, I paused at that word, you know, although then the question is if you go on, how is it if you read the whole thing? And there is the clarifying instruction. But I didn't see it as preserved by something that was said there. But we'll look.
Thank you. So what makes this case unique is the jury question. It is exceptionally well written and clearly implies that the jurors had reviewed the written jury instructions very carefully, thought about them, and then wrote what they considered to be the conflict or the contradiction. And really, it's whether negligence has an impact of whatever variety, great, small, medium, any slightest impact, whether that's sufficient. And I think that is the thrust of what the jury was questioning.
Okay, but so then where you lost me on that one was, what were their alternatives that they were given? Like for what caused this?
In the case,
Yeah.
okay, so Nancy McDonough had undiagnosed atrial fibrillation for we don't know how long. We don't know if she showed up at the hospital before Dr. PAUDEL ever treated her, if she had clots in her heart.
You're asking about the proposed other instruction, right?
Well, I'm asking that you're saying that there might have been different causes and was this a but-for cause, right? And I'm like, well, what were the other options? Like, obviously,
I'm
she
sorry.
didn't get treatment before then, but now she's presented at the hospital. They have this opportunity, and you're only, I know, I get it, you're trying to reduce the risk of stroke. You can't eliminate the risk of stroke, right? So, but that presumes there were other causes floating around.
A pre-existing clot that existed before she came to the hospital.
In her leg, you say.
I'm sorry?
In her leg, you say.
No, in her heart. So the patient had a condition called...
They didn't do anything. She comes in with AFib and they don't do a transesophageal examination to see if there's already clot there. Okay.
No, Your Honor. I think I know the case you're referring. I was part of that one. I was here a few years
No,
ago.
I'm just
But
talking
no.
about what you do with people with AFib.
Right.
Get
And the
back to
answer...
the issue of waiver for a moment. If you look at trial transcript 3, volume 3 at 1172, I'm having a hard time, and you certainly had a discussion. First of all, I very much appreciate the fact that you started out acknowledging an SJC decision. It's admirable, and I appreciate that very much. Secondly, you were very close on your record citation. I'm having a hard time, though. There was a lot of back and forth, and we don't have enough time to go through this, but at the end, I'm just reading this, and it seems as if you say to the judge, I think if there was a different question, but we really don't know what the jury's asking, so I think you should just re-instruct them on what the instruction is. I had hinted about this with the issue about causation in the past, and this might be, but since this question doesn't really have anything specific on page 1171 to 1172, I think you should just re-instruct them and tell them to follow the instructions. I don't see, even if you didn't use the word I object, even something that...
That is consistent with my memory, Your Honor.
Yeah.
What I was attempting to say, and I apologize if I said it poorly, was I did agree that the judge should not respond to the question because I didn't think the analogy of a wrong site surgery based on insurance paperwork, I thought that was very inappropriate in the context of this case. And so when I said yes, I don't want you to say that. What I was trying to prevent was the analogy.
No, and you do say, I mean, I get it, it's trial, and it's always nice for me to look at a trial transcript and go, oh, you didn't say it, but when you're in trial, it's a whole heck of a lot harder. And you do say, I'm not retracting or having any of my objections to the instructions I previously put on the record. You do preserve that piece, but the waiver issue seems to be pretty big issue in this case, to me.
I think what I'll say is it seems like there's a waiver, so unless you can point me to a transcript page where you specifically raised this issue, I think it's waived.
Your Honor,
and
I
if you
did
don't
not-
have it at hand, that's fine, but then I get it to us today, because otherwise I don't see it.
I did not object to...
it's my
I'm
view.
sorry. I did not object to the impact language during the charge conference or after the instructions were provided to the jury. I did not. There's no disputing that.
I appreciate your candor on that.
The question came up when the issue arose when the jury asked this question. So I don't think the analysis of this case is really whether it was preserved at the jury instruction stage, but rather the response to the jury's question, which gets to the broader issue of how much confidence do we have in the jury's verdict. So what I would say is I don't agree that I waived it. I certainly didn't intend to, but even if I did, that's not really the issue before us. Although Luppold may make this argument a bit.
So you're saying unless you can distinguish Luppold, these instructions were fine?
I can distinguish Luppold, is what I'm saying.
And you're saying it's distinguishable because in this case, the jury asked a question, so we know they were not clear.
I don't think today is the time or the forum for me to contest Luppold.
That would be a tricky thing to do.
Occasionally, I'm the master of the obvious, Your Honor, but
Well,
only occasionally.
We certainly cannot overrule Luppold. What I'm saying is if we follow it religiously, scrupulously, does it mean you lose? And all I've heard you say is no, because in our case, the jury asked a question. Is that right?
Mostly.
Okay, then fill it out.
I agree that under Luppold, and the time may arise in the future to contest that with the SJC, I don't know the answer to that. But given the Luppold decision, the judge's response to the jury's question was appropriate. But it still leaves open the question of whether it adequately addresses the jury's question. Because what they said,
But you said it did. You said that it did at trial, right? You accepted the instruction.
the jury question was whether negligence has an impact without any sort of threshold screening of how much, how little, or whether it had the slightest impact at all, whether that's sufficient to establish causation. And a slight impact is not but for. Now, I agree that this is something the SJC needs to address. This question, it was my understanding that this question from the jury, the lawyer handling the appeal for the appellant in the Luppold case sought to introduce this question to the SJC. And it's my understanding the SJC did not consider it. If they had, then this argument may even have been shorter than I've made it. But they didn't. So whether or not the model jury instruction, the response of the court to give the jury instructions again as a whole, whether that adequately addressed this jury's question, I don't think is clear. I understand today where that argument goes, and it may be something the SJC considers in the future.
So he's going to get up in a minute, I'd like to forecast the future, and he's going to say that here it's all fine because the judge said read the entire instruction and you have to satisfy each piece of it. And so because it says it's got to be a but-for cause, that covers it. What's wrong with that argument?
The instruction as a whole doesn't provide what an impact should be. Under Dual, the notion was to exclude those causes that had no impact on the harm, which we can all agree with. But to say then that equates to causation can be established by a negligent act that has a very slight impact.
Well, I mean, the
SJC
SJC in Hanlon says, Hanlon suggests impact could mean that the negligence may have some, quote, effect, unquote, or, quote, impression, unquote, such as making the harm, quote, more likely, period, unquote. And that sounds pretty close to what you're saying.
It does. But the jury's question, I still maintain, Your Honor, the jury's question was not answered by the judge's response, even though it has been approved by the SJC in Luppold. The jury was not told that there has to be some threshold of impact, and that a slight impact.
Now, how can we review that? Did you object to the answer? I thought you said it was okay with you at trial.
Oh, at the trial I did not. I did not.
How can you raise it here? We don't do substantial risk of a miscarriage of justice in civil.
Understood. Understood. So I acknowledge the implications of Luppold for today's argument.
Okay.
But there are a couple of other arguments I would like to address, and I see I only have about 35 seconds. So, informed consent. The whole fundamental premise of informed consent is patients should be told things they don't already know so that they can make appropriate decisions about their own health care. In this case, leaving aside the factual disputes about what was said, what wasn't said, it's undisputed from the plaintiff's own testimony that he and Nancy McDonough, the deceased, knew the risk of discontinuing the anticoagulation for her having atrial fibrillation. So with that in mind, the plaintiff did not satisfy the fifth part of the Harnish versus Children's Hospital Medical Center test, meaning the unrevealed or unknown risk materialized because she knew of the risk.
Okay, I mean, we understand. We have that argument in the case about when you can and can't have informed consent be a separate theory. And I assume the other thing you were going to talk about is the truncation of cross-examination and how wide a door was opened, if at all. And we have those arguments as well.
Lastly, prejudgment interest, and whether it should have continued to run throughout the whole COVID
Did
period.
you raise it before the trial court?
In the motion to amend the judgment, I did.
Okay.
So is it clear, there's this continuance because one of your co-defendants asked for continuance and your client agreed to that. But is it clear on the record how much of the delay was specifically related to COVID-19?
So the first trial date was in August of 2019. A then defendant who wasn't present at trial asked for continuance, so it was rescheduled to March of 2021.
I don't understand these 2-year reschedulings you all are doing. I find them absurd, but whatever. So on the day that it was rescheduled for, there was no order in effect from the SJC limiting jury trials. I understand that there might have been difficulty getting a jury, but the COVID orders were not in effect on September 2021. Is that correct?
Well, the civil juries reopened fully in July of 2021.
Okay, so
trial,
all of the time that there were orders in effect didn't affect your case because here it is September 21. Now then, the judge says, let's do it on another day, and once again, for reasons totally baffling me, you all agree to do it 3 years later. All right, 2.5 years later. I don't witnesses die? Don't people's memories fade? I don't understand what's going on in the trial court, 2-year continuance. But
if it's any solace, I live it every day, and I don't understand it either, Your Honor.
well, in any event, you agreed to it. The judge didn't say I'm doing this because of COVID. Obviously, the COVID things have some ongoing impact forever. Of course, they also haven't said prejudgment interest is told by COVID.
No, but the initial orders about the COVID exigency did talk about deadlines contained within statutes. So and yes, they didn't specifically mention prejudgment interest. I can't dispute that. But the fair inference is that those orders were intended to apply to prejudgment interest as well.
So are you contending that the plaintiff should bear the full burden of the delay, or are you contending that it should be split in some way?
In a balancing of equities test, Your Honor, I can't stand here and tell you the plaintiff has some responsibility for COVID or the delay in the trial.
No,
but
neither one
does
of
the
you has
defendant.
any neither one of you caused that. So the question is, if we were to divide the burden, right now it's all on your client. If we were to say, because we do try to do justice, that's not really fair, what would be fair?
Sometimes we follow rules, even if they are unjust in a particular case, but go ahead.
That I'm going to refrain from commenting upon, Your Honor. What would be fair, Your Honor? I think tolling the interest for the period of time in which civil jury trials were not available.
It didn't
That's all
affect
on
your
him.
case at all.
But it did, Your Honor.
No, because you agreed to a time well beyond when all of those delays were taking place.
The second trial date, the first trial date was continued, but the request of the attorney for a former defendant.
Okay.
The next trial date was squarely within the COVID period, March 2021. And then we got another trial date in September. That was the third trial date. And it's not clear on the docket, and I'm not going to stand here and say who said what and all of that, but it's my understanding that we didn't get reached for trial in September because of the difficulties and reluctance of jurors.
You agreed to, in 2019, you agreed to March or September? I thought September was the next trial date.
No,
March?
August 2019 continued to March of 2021.
All right, your time has expired, but we will certainly ask your opposing counsel all about it. Thank you very much.
Thank you.
If there are no further questions, which I doubt, We will next hear from Attorney Satin.
Thank you, Your Honor. May it please the court, Adam Satin for the plaintiff appellee. Just on the prejudgment interest issue, since it just was raised, there was not a trial date that his client was deprived of because of COVID on this record. The trial date that was original was set before COVID, and the first date was moved before COVID to a date after all the COVID
let's say
orders.
we agree with you that March 2021, he stuck with that. But now there's this, and then there's a delay to September. I don't know whose fault that was. Right, but then you couldn't get a trial. Could he have done anything to have gotten a trial sooner than the trial he got?
Well, certainly, Your Honor, by advocating for an earlier trial date than the one we got. That trial date was not. I'm sorry?
I find extreme positions aren't helpful. So it seems reasonable, but you can tell me it wasn't, that there was some delay in this case attributable to COVID. Do you think there was no delay of any kind attributable to COVID?
What I can tell you is that continuance of September 20th, 21, on the record in this court was not reached by court. Now, not reached by the court. It's volume 1, page 16 is the endorsement. It is not expressly because of COVID, and cases.
Oh, it's not necessarily because of COVID, but once you say we're going to give up the September 2021, there was some reality as to when the next trial date was going to be because of COVID, because we weren't trying cases and so it got all backed up.
So it's a little hard for me to remember back as to when, in practice, that date of September 20th, 2001 is after all the COVID orders are over.
Was there a March 21 date?
There was a March 21 date that was moved before COVID by another defendant.
When was it
with his
moved?
assent.
It was moved after this August 2019 meeting?
I'm sorry, one more time, sorry.
In August of 2019, a trial date was set for 2021. What date was set? March or September?
My understanding is that continued the March date to September to September of 21.
Why were you having a meeting in 2019 about which day 2 years from now there's going to be a trial? I'm baffled by this.
So the likelihood is that the defendant at the time who moved to continue had some problem or conflict.
On March something of 2021.
I honestly was not the trial lawyer at that time.
Okay.
What I will tell you is that that March 21 date was moved in August of 19 before any COVID.
Okay, I see. All right, so my original premise in terms of fairness, which of course Justice Henry raised, is that there's nothing unfair about applying these rules because the COVID regulations didn't affect the date of the trial.
It never expressly.
And even if it did, the SJC has never said prejudgment interest is to be altered because of that.
That is correct, and in Luphold, ironically, there was, I guess not ironically, I should say, it was Mr. Bruce's firm who represented the defendant in Luphold, and it was mine that represented the plaintiff in that case, so we're both intimately familiar with both cases. Interestingly, in Luphold, his partner advanced the argument that prejudgment interest shouldn't apply because of COVID in the trial court. Judge Barrett in that case said, denied that, totally abandoned on appeal.
But the SJC didn't reach it.
I'm sorry?
Didn't the SJC decide it on a different ground?
They advanced it at appeal on a different ground. They abandoned the COVID argument. And
okay, so we don't have an appellate ruling about the COVID argument.
What we do have, Your Honor, is a clear indication from Luphold at, I believe, page 35 of the slip opinion. The prejudgment interest is mandatory by statute. It is not subject to this idea of weighing whether interest was someone's fault, not someone's fault, nobody's fault. It is mandated to be applied as a ministerial act on the whole judgment from the beginning of the case, the
You're
commencement
saying
of the
there's
action.
no relief valve of any kind for a once-in-a-century, I hope, global pandemic?
So the SJC could have said that in any of its orders, did not, and Mr. Bruce has provided no authority for any of this type of sort of, the term relief valve that you're mentioning, Your Honor. And the reality is that this case, you do not have anything in this record to say that this long delay was because of COVID.
So if a fire burnt down, knock on wood doesn't happen, the courthouse that your trial was scheduled.
Things happen all the time.
That pandemic was to the extreme, but things occur, and there's no equity in balancing. If the SJC, in its inherent authority, wants to toll,
There's no.
Wait,
interest for a particular court for a particular reason, or for the entire court for a big reason, it can. It chose not to. So absent that, your argument is there's no authority to do so.
That's
It's
correct.
not inequitable except for the interest rate. Right, the statutory interest rate, as is well known, although it's getting closer and closer to being a market interest rate, unfortunately, the statutory interest rate is an absurdly high 12%. I mean, that's really the problem here, because the truth is the other party, by hypothesis, has the money and it's invested, and so they're getting interest on the money at the same time, and your client doesn't have the money. But of course, the interest rate is 12%, so that there's no way, I know there's some case that says the stock market goes up 12% a year, and if that happened, I'd like to meet the broker who's getting that for his clients or her clients. But that's the inequity. Simply charging interest isn't inherently inequitable.
But that's a matter for the legislature, and they have dictated with a reason why it's 12%, Your Honor. And it's been 12%. I've been doing this a long time. It's been 12% under 6B, 231 Section 6B, and 229 Section 11 for as long as I've been doing this type of work. And
Well, interest rates used to be like that.
But the reality, Your Honor, is, and I believe Luphold comments on it, there is an affirmative intention on the part of the legislature to promote early resolution of cases. And that is part of their reasonable lawmaking function that is not to be second-guessed. We can write our lawmakers and see if that can be changed. I won't be writing that letter, but the reality is that it's for them to set, and they did set it, and the SJC has said it is mandatory, not something subject to, and incidentally, there's been no suggestion by the defense as to any authority to have a relief valve for the continuances. Continuances happen all the time. This case, there was not a continuance at any time by the plaintiff, and the only circumstance, and we mentioned it in the brief, is with recalcitrant behavior on the part of the plaintiff, who then, in a manner, sort of forfeits the right to it. So we don't have anything like that in this case. I do want to address.
Going to the jury instruction for a minute, I don't see the actual transcript where the jury's re-instructed, but are you agreeing that volume 4, page 206 is the instruction that was read to the jury after they asked their question? Or where am I missing in the transcript the re-instruction? I see the back and forth with counsel.
So I'm sorry, volume 4, page 206 is the correct site, and what I can give you, Your Honor, is volume 3, page 1180, Mr. Bruce saying, "I am content with that."
Right, I got that. He said, yeah.
And so I do believe there was waiver, and incidentally, Mr. Bruce says, "I didn't raise it before deliberations, but oh, there was a question." I'd like to address that, because in that discussion, Mr. Bruce did not think it was the impact language that was at all confusing them. He thought it was the next paragraph, and the SJC and Luphold has looked at an instruction that is essentially identical and has approved it in all respects. And Judge Barry Smith, who did what he did by sending back the jury with what is confirmed by the SJC to be a correct instruction on the law of but-for causation, told them, without the benefit of Leupold, told them exactly what the SJC has now told everyone, which is we don't look at this with a couple of sentences or fragments. We look at the instruction as a whole, and the SJC decision in Leupold is extraordinarily clear as to why it's a correct principle of law. Like Leupold, this instruction was tracking exactly the model instruction, which the Leupold decision says is deemed correct.
Given that we have the benefit of Leupold, turning to the expert testimony, you contend that it was undisputed that this theory about the, it's spelled like Lovenox, but is it Lovenox?
Lovenox.
Lovenox, okay. I like Lovenox but way better, but you contend that that drug stayed in her body because her kidneys weren't clearing it, and that opinion, or they contend that opinion you contend was not in a pretrial expert disclosure, and you cite to Record Appendix 3, page 928. But when I go to 928, I don't see that. I actually see a big dispute about it.
So that is not the disclosure, that is the trial testimony, so you're correct. There is no dispute that it was not in the pretrial disclosure of any witness or expert.
Okay.
So that, I can supply the expert disclosure citation hopefully in a moment.
I mean, in 925 or 928, at first he says, the court says, is this in the disclosure? Mr. Bruce says, this particular language, no, but it's part of the overall case. But then, when you keep reading, because we do that sometimes for context, then it's like, oh my gosh, this does not seem undisputed. Because then it's like, I mean, there's pages where you're going back and forth here. Yes, pages. And so now I'm like, I'm lost as to whether it's undisputed. Because he seems.
Oh, no. It was, the whole dispute arose, Your Honor, because the attempt by Mr. Bruce, which the trial judge felt was misleading this jury, is that what the nephrologist said as a fact witness about the fact that she had kidney failure and that could leave some persistent effects of the old medication, that in no way got Mr. Bruce to what he was trying to suggest was now the testimony.
Well, presumably he didn't ask the nephrologist, would it be enough to anticoagulate her, because he knew the answer would be no.
Absolutely.
I don't know. I don't see how. I mean, I have to say, even without an expert disclosure, if that had been the testimony, of the nephrologist, it might have opened the door to the expert being asked, but why was heparin, even if it wasn't, why was heparin contraindicated? But I don't think the door was open because he never gave that answer.
So, and I'm just not 100% sure whether you're talking about plaintiff's expert Cross or his own expert later.
I'm talking about on Cross, he says, what about X?
Right.
Wait, on Cross, you say, wait, I can't, now I'm getting confused.
So if I may.
Yeah.
The complaint, which are all the most discretionary rulings in a situation of experts being examined on both ends, 100% discretion. The plaintiff's expert, he wanted to suggest, and this is what Judge Barry Smith found was going beyond what he had gotten from the nephrologist, was he wanted to suggest that this was like having a permanent dose of Lovenox, good forever because it wasn't clearing. And that is not what that testimony was.
But on Cross, when the judge says, you'll get to do this on redirect to Mr. Bruce, It's
That's a
because,
different witness, but yes.
no, this is the witness I'm talking about.
Okay.
You're asking essentially whether the Lovenox was inadequate, even with kidney failure, to anticoagulate the decedent adequately. But you never get an answer to that. If you got an answer to that question, maybe on redirect, you could ask, it seems to me, you could ask this expert, even though they hadn't disclosed it or whatever, what are the reasons that you shouldn't have given heparin regardless, and then you'd get into maybe this liver stuff.
So,
But the door doesn't seem to have been open to me because there was no such answer on cross.
and to be clear, Your Honor, that's Dr. Weinstein who was
Okay, yeah,
on the stand.
I do think I'm mixing these two witnesses up.
And Mr. Bruce's brief indicates that my colleague, Mr. Thompson, opened the door, quote unquote, and then in their brief, they tell you how he opened the door by saying that that he asked affirmatively this expert whether IV heparin should have been given, which is clearly a standard of care question. And what I want to point out is that that was absolutely nowhere in that question. The actual question was whether IV heparin as a medicine was an alternative medicine to Lovenox to prevent blood clots in the heart. That was what the witness then took, a very well-traveled expert who was intent on now trying to defend the standard of care part of the case, and what he said was, it shouldn't have been given for 3 reasons. Not responsive.
No,
It
I
was
think
excludable just
we're
as
aware
not
of that.
responsive.
I just had one question on the informed consent, which is he argues that she already knew all these risks because so many people in her family had atrial fibrillation, so she knew all the stroke risks. And so therefore, your informed consent argument should have, I think, been directed out, but should have been, what's your response to that?
Your Honor, she knew that she had atrial fibrillation now diagnosed and that the Lovenox was an anticoagulation. When the Lovenox was stopped, there is no evidence from which the jury could have possibly concluded that Mrs. McDonough knew about his client's proposed course of treatment, which was subcutaneous heparin with aspirin,
Yep, we don't.
versus IV heparin. There is no basis to think she actually had knowledge about the specific course of treatment he was proposing, and I really would be remiss, I know my time's over, but if you'll indulge me on this, the jury found negligence as to which there was absolutely no dispute as to the quantum of evidence or the
Okay.
propriety of the case.
I think we are aware of the jury's verdict and all of your arguments, and your time has expired. So thank you both very much. Very helpful arguments for us. We are going to take our traditional mid-morning break, and we will return to hear the remaining 3 cases in 10 to 15 minutes. Welcome back, everyone. Our next case is this right? Is a Department of Children and Families case, DCF versus Mother, number 24619. Of course, this is an impounded case, and I'm sure you will all take care not to use the names of the individuals involved, maybe child, mother, father, and so forth. I gather the appellees are splitting their time. DCF 6, mother 6, child 3? Okay, it may take a little more than that. We've been going over all morning, so maybe we will all afternoon as well. Having said that, we will hear first from Attorney Heffernan.
Thank you, Your Honor. Good morning, Your Honors. I'm sorry, good afternoon, Your Honors. May it please the Court, Peter Heffernan on behalf of Father. He is watching this afternoon via the YouTube link. Your Honor, I'm asking the Court to vacate the order of the Juvenile Court adjudicating Father unfit to parent his now 9-year-old son. And I'm making this request because the trial judge's findings fail to demonstrate Father's unfitness clearly and convincingly, and fail to state the required nexus between Father's conduct and risk to child from abuse, neglect, or other harmful activity. A parent's thoughts, beliefs, and mental health diagnoses are relevant to the question of parental unfitness to the extent that they result in conduct that puts a child's welfare much at hazard. The Court makes many generalized statements assessing that fathers presents a risk to his child. However, if we drill down into the findings, looking for the factual support for those general conclusions the Court reaches, we don't find what we would expect to find there. I'd like to, if I may, just begin with talking about something that the trial judge she largely ignored in her findings, and that is Father's strengths as a parent. Father was child's sole physical custodian from February of 2019 through till the trial judge transferred custody to DCF in 2022, in May of 2022. During that time, child was well cared for. He had stable housing. There's very little evidence in the record that Father was not appropriately taking care of child for that entire period that he had custody, that he was the child's primary caretaker. Mother had weekend visits for the first year of that period of time, but when she moved to Virginia, Father was the only parent dealing with child's day-to-day needs. DCF in 2022 consistently observed Father and child in their home, and observed child to be well cared for and comfortable with his father. Most importantly, and I don't think there's any dispute here, that there is a very strong, or was, at the conclusion of the trial, determined to be a very strong bond between child and father. In the spring of 2022, the court investigator asked child, "What's it like living with father?" And child said, "I like it. I play a lot with my toys, my hamster, and daddy. I go on his back. He carries me around like a horsey. I love dad." That's what was observed of father's parenting in terms of his day-to-day parenting and interaction with the child.
Can I ask a question?
Yes.
I know you used the past tense. Do they still have a strong bond? Are they continuing to visit at least by FaceTime?
That would require me to go outside the record.
But I want to know.
Yes, my understanding is father is consistently visiting with child.
And in terms of review and redetermination,
yes.
Have any such petitions been brought during the interim? They're allowed every 6 months, is that right?
Yes, that's correct, Your Honor.
Has any been brought?
I have not looked at the juvenile court docket, so I don't know to answer that. I would, with respect to review and redetermination, just point out that
the burden is the other way.
The burden is on
yes,
father.
I understand.
He's differently situated, and it is not particularly relevant to the question before us today as to whether or not.
No, but I'm just wondering, because it seems like, and I'm not a psychiatrist, but it seems like maybe trying some of these medications might ease the thought disorder that whether it's enough or not is the root of this problem, because obviously they have an incredibly close and loving relationship.
Yes.
And it's terrible to see it, well, to see any child's bond with their parents severed, so.
So, Your Honor, turning to, I do want to point out one thing about this case is it's unusual in respect that there was no emergency response by DCF. There was no emergency removal. There was no single incident in the record of father behaving in a way that put child's welfare at risk to the level that DCF would need to go and intervene. This was, the transfer of custody to DCF happened in court due to father, the court finding that father had failed to abide by some of the conditions, particularly getting child a therapist. But I would like to address some of the...
Counsel, though, is that then an indicator that the father can't put the child's needs before his own?
Well, with respect to the therapy, Your Honor, what I'd like to address that, this is a complicated case. Father had concerns about whether child had experienced, had been the victim of sexual abuse. Throughout that comes up in the record in February of 2021. There's no evidence that the child is assessed or evaluated by a qualified evaluator who could assess the sexual abuse allegations. There was, hospital staff looked at him, DCF talked to him, he had one therapist, and this is where I'll get to that point, Your Honor. That particular therapist, it was father's understanding that she was going to work little by little with child without pressure to address that, to see if there was something there. That was father's expectation. She indicated to him after the second Zoom meeting that she wasn't going to do that. That's not something she did. Father felt, given his information and understanding about that issue with the child, felt that it was a priority for him. Now, I know it's reframed as father was seeking to compel people to reach this opinion and provide him with a report that said the child had been a victim. I know it's framed like that, but if you look at father's testimony and even the response from the therapist was that I said I don't do that type of work. And father said, okay. He then pivoted to trying to find his own therapist. He called 20 to 25 different agencies. He was unsuccessful, and in May...
I mean, the trick here, I guess, in a way, we don't have a factual finding about the child's initial complaint, right? We know it happened because there's a recantation at the hospital. We don't have data. One of the appellees, maybe the child, says, oh, it was because they were forced, blah, 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 whatever. That's not in the record at all. And ordinarily, I think I agree with your general view that when we hear an allegation of sexual abuse from a child, we take it gravely seriously and look into it in a lot of ways. But there are these factual findings that, well, it was looked into at the hospital. I mean, I don't know how much weight you give a recantation by a child, but also, I don't know, there were no findings about it, but there's this evidence of him crying as his father talks about it. It seems to me that maybe, even if the initial allegation was true, the obsessive focus on it with the child in the way that the father was doing it is not how you handle something like that. If you're not content with the outcome, maybe you talk to experts, but you don't, bring the child repeatedly to different places and ask them, even if that's not what you're there for, about it. You don't constantly ask the child about this because you're maybe doing terrible harm to the child, even if they were sexually abused. Do you have an answer to that?
I guess my concern there, Your Honor, is where is that evidence of him? The court concludes that he brought child to multiple doctors and therapists seeking corroboration and treatment for sexual abuse. If we drill down into each one of those...
Every single time they go to see anyone, even if it's a checkup, it's not about, or whatever, he asks about sexual abuse with the doctor or medical provider. Every time. It's clear that he's, and maybe you would say justifiably, although the court makes findings by a preponderance of the evidence that it's a result of thought disorder, paranoia and delusion, which I guess the judge does based on the conclusions reached by clinicians who saw the child, including one saying, I get the sense that he's being asked to say stuff that isn't true. Again, I'm not, we're not a trial court.
Right. I believe Your Honor has identified the one visit that father brings the child to where a doctor, a medical person actually says, I was concerned, I thought that father may be encouraging the child to say things that I wasn't sure was true, right? But if we drill down on each of those, that's other than that, the only evidence of anyone observing father's conduct in saying, I'm concerned about his interaction with his son, was the therapist who complained that father hovered during therapy. I don't think, she doesn't say father says anything. She doesn't say father tells child what to say. That just her concern was, I'm concerned that he is, having some influence over how child is interacting in this therapy because he's hovering. But I don't think that rises to the level of, as a basis for parental unfitness.
So if I understand your argument correctly, you're not denying that there was at least evidence in the record of paranoia and delusions by father in general.
I'm not claiming error on those findings, Your Honor.
Your claim is that in essence, there wasn't sufficient facts tying his whatever mental health or beliefs that he has to being an unfit parent. And so, sure, while he may believe that phones are recording and that certain people are police officers and he has to run to Brazil and all the rest, that he was still a good parent to child, as shown by there was food in the house and they had a good bond and there certainly a degree of love between the two that is to be commended. And I understand that's your interpretation, but it seems to me that the judge was free to accept that interpretation or to consider the other one, which is that his failure to address his mental health has had such an impact upon the welfare of the child that renders him unfit. So that by continually, when I say continually, we can back and forth about whether that's continually, but by repeatedly exposing the child to delusional and paranoia thoughts about him being inappropriately touched or that he can get an STD by sitting on a toilet, et cetera, that his mental health and failure to address his mental health and following an action plan has rendered him an unfit parent. There does seem to me to be that connection that was expressed. So tell me why that's wrong, that the judge could have found for your client, but that the evidence was there to say his failure to address his delusional and paranoid thinking has impacted this child by creating this environment where the child is in a situation where at every turn there's an accusation or a belief that just isn't there.
I would just turn to the weight of the evidence that supports that position as being thin. In terms of, we're talking about, in terms of father bringing the child to the doctor, over a 15-month period, there were a total of 4 medical appointments for this child. He was not, I understand there's a way to frame this where you say, we're concerned about this parent because they're constantly bringing their child for unnecessary medical care, right? And asking for testing, et cetera. Over the course of 15 months, we have the initial emergency room visit because of the child has blood in his stool and has made a disclosure. There's no further visits until we get to August, and the child has physical symptoms, is brought in. I just would argue that the evidence does not support this notion that he was just every day hell-bent on proving this point. And I think the court, in many respects, presents evidence in a way to make him look like he's doing this in a worse fashion than he was. For instance, Your Honor references the toilet seat issue. The judge makes the conclusion that father believed that the child could, that's her finding. Father believed the child could contract a STD from a toilet seat. If you drill down into the actual appointment and what the provider said, she said he asked the question.
I heard that.
Can I ask you, I know your time has expired, but I have a couple quick questions for you. At various times, both the court and the appellees refer to the father and child being in a shelter. Everything I see makes it look like it's either maybe a studio apartment. So I don't understand, although there's also some reference to shelter staff. So I don't understand, were they in a shelter? Were they in an apartment?
It was in all effects an apartment, Your Honor. It was a DTA place apartment.
What does that mean, a DTA
Department
apartment?
of Transitional Assistance.
No, I understand, but I know DTA, but what does it mean for them to have an apartment? Is it an apartment that could have been rented to anybody, or is it inside an institutional building, or what?
It's an apartment that could have been rented to anybody that father accessed through applying to the agency.
So was a shelter involved in this ever? Is that a shelter? Do people call it a shelter?
I would not call it a shelter. It is an apartment. You could say it is it's an emergency. There's different ways to look at it, but what it was, in fact, was a studio apartment. He was never in a shelter sharing, that implies that he's...
No, I know what a shelter implies. That's what I thought, but then I hear some...
That never happened.
Okay.
Is my understanding.
And my second question is, did you object to placement with the mother at trial? Or is that waived?
The counsel did not object, and I am only pointing that out. I'm not, in my brief, I'm raising that issue just as evidence that the trial judge was not paying close attention to the evidence. I'm not raising an objection to that order.
You don't have some alternative idea if he doesn't get custody right now that the child shouldn't be with the mother, should be you've never proposed anything anyway.
At trial, that was not proposed.
Okay. All right, thank you very much. We will hear next from Attorney Gallup.
Good afternoon. Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the judgment of the lower court finding father unfit and committing the child to mother's permanent custody. Now, father makes arguments as to erroneous findings, but if you look at the cumulative evidence beyond just the issues related to the sexual abuse allegations and the evaluations, that father was unfit and that his unfitness did in fact impact the child. There were, I believe it was in December or January of 2021, January 2022, at that time, the child had 23 absences from school.
In kindergarten or pre-K, what grade was that, do you know?
I'm not aware, I don't, it was significant, I don't know what year in school he was at that time, but it was significant enough for the, such that when he ended up being placed with his mother, he was behind educationally and he required a tutor, or I believe he required some sort of additional extra support.
Okay, but if it was kindergarten, it's a lot different than, 4th grade or something.
Certainly, but a parent has an obligation to send their child to school.
If, once they're in kindergarten, they do, yes.
So, you know,
Right.
the instruction missed, you know, whether it was, you know, at kindergarten level versus fourth grade, there's still an obligation to ensure that your child is in school and interacting with peers and other trusted adults. Additionally, there were moments where several, I believe at least the child's pediatrician, in speaking with the child at, I think it was August or September, so before the department filed the petition, the pediatrician met with the father and the child and determined that the child would benefit from therapy and offered to have a social worker from the pediatric practice meet with the child in the interim while a therapist for the child was identified, and father failed to, or no, declined to pursue that service. Additionally, father, you know, before the petition was filed, went to Virginia after he, so let me take a step back. In May of 2021, father decided abruptly to go to Brazil, and he left the child with the paternal grandmother, didn't leave any sort of caregiving affidavit, so she had no, you know, legal authority if the child needed to go.
Is that problematic?
Well, it is problematic in terms of if the child suffered some sort of medical emergency.
People who go out of town and leave their child with a grandparent usually fill out some paperwork?
If they're going for several months, I would imagine they would.
You would imagine.
Yeah, well, I mean, a parent has an obligation to ensure that the child is cared for.
I'm guessing most parents don't have any idea that there's paperwork that needs to be filled out. I mean, I have no idea. Did we know that was he told that you better fill out a whatever? I don't even know what the document would be.
He left in May, and during that time, the child was still in school.
Mm-hmm.
So now, if the school needs to call a parent to report a concern, there's no person that they're calling on the other line who has any authority at that point. So mother had to come up from Virginia, retrieve the child, bring him back, you know, bring him back to Virginia, enroll him in school, get him a therapist. Then when father returns, he removes the child from mother's life, doesn't give her any contact with her son.
He has custody, right?
At that point.
He had sole physical custody.
Oh, yes, according to the probate and family court
Okay.
order. Now, but that doesn't.
All of the, I mean, we have a short period of time
Sure.
here. All the before
Yeah.
petition, comparatively speaking, my opinion, isn't that much, right? There's some absences, left without, you know, some forms, didn't get a therapist, but that wouldn't in and of itself be enough to support unfitness. The heft of the argument was about father's delusional and paranoid thinking and how it affected the child, correct?
Correct.
And you think there's enough evidence there to support the finding of unfitness?
That's the department's position. Additionally, you know, after the child.
One of the questions I have is in a situation like this where the child ends up with the other parent, what is the benefit to the child of actually terminating the parental rights? Like, for example, if his client goes out and gets killed tomorrow, this child won't be able to get that guy's Social Security because you've severed the legal relationship.
No, there's no termination in this matter.
Okay.
Are you asking for theoretically what could happen?
Yeah. Yes.
But the department did not seek to terminate parental rights.
So what does that mean?
What does what mean?
That he has rights, but there's permanent custody, legal and physical, I gather, in the other parent. I mean, I understand he has the right to consent or not to adoption and, you know, those kinds of rights. But he has no other rights with respect to the child.
So right now, as it stands, the juvenile court order is in place. If the care and protection matter was dismissed, then the underlying probate and family court order would be revived. So, and then it would entail basically contact and physical custody, you know, legal decision-making between the parents. And, I mean, it's my understanding from the record that at one point the juvenile court judge did try to transfer the case to the probate and family court, but it appears did not.
But the probate and family court then said no thanks. Thanks.
Yeah, and I think that maybe it was because they didn't do it through the, the,
Well, no, there was a detailed order that explains why, which is we have no resources here to actually look into any of this. It'd be better if you did it.
but it's my understanding that you can have a probate and family court judge sit as a juvenile court judge.
But there,
through
whatever,
the
that's not before us. There was no
interdepartmental-
objection to this from anyone, right?
Correct. But I guess, I don't know if I answered your question, Justice Henry, but that, right now, the juvenile court order is in place. Once this is resolved, and I would imagine that the CMP will be dismissed, the family court matter is controlling, and then
So what happens now that the kid is in Virginia? What is DCF doing to supervise that? I assume the case isn't transferred to the Virginia courts or Virginia's version of DCF because it's an ongoing case here and at least one of the parents is here. So what is how do you oversee what goes on?
So when the child was placed with the mother, through an ICPC, the Virginia Child Welfare Services was monitoring the family at that point. But then when mother received permanent custody, that contact ceased, and the department doesn't really have much contact.
So you don't know if he's hit by a belt? If that happens, you won't hear about it?
I don't want to misspeak, and I believe that my brothers might have a more, factually accurate
Okay.
answer for that. But so what the department, I'm sorry, if you could just remind me what you were asking me about.
I was asking if something bad happens in the house. I said hit by a belt because there's at least some evidence of that happening once, although I'm not saying it did. And there's certainly the father believes there's a question about sexual abuse. I'm just wondering what oversight there is. I mean, there's a care and protection here. Presumably a court would want to know if having ordered custody to someone out of state who frankly left the state without her child, whether that's going okay, because otherwise they may have ordered something terribly wrong. Are you relying on the father to find out what goes on?
I would be relying on, don't want to misspeak here, the child welfare system in Virginia, though, who is, has access, the child is in school there, he's in the community, so I apologize, I did misspeak. The Virginia DCF is providing monthly contact.
I see.
With the family.
On behalf of DCF, or it's got some open proceeding? Well, I'll ask your brother who.
Yeah, all right. Seeing that
Okay,
I've
your time has
over my
expired.
Thank you.
Thank you very much. And we will hear next from Attorney Shokier.
Good afternoon, Your Honors. May it please the Court, Richard Shokier on behalf of the appellee mother. She joins the department and the child asking...
Could you speak up, maybe move the microphone closer?
Certainly. She asked this court to affirm the orders of the lower court. If I can just quickly address this, the Department of Children and Families in Virginia provides monthly reports to DCF in Massachusetts, and there's an assigned social worker with the home, with the family in the home.
And does that social worker make home visits and things like would happen here?
I don't have any information as to that. I'm assuming here they have to do monthly visits and provide contact, but I can't speak to that. My argument is that father essentially makes three arguments on appeal: that there was an insufficiency of evidence, that there was no nexus, and that the judge just completely ignored evidence of mother's unfitness. If I could address those in order. There is sufficient evidence that was placed before this court, both testimonial through father's own presentation with the judge, and reports from the department and collaterals, therapists, pediatricians, that father did seek out medical advice to sort of gather this idea that he has that mother's husband had sexually abused the child. His delusion is evident.
Well, usually when a child reports sexual abuse,
Yes, Your Honor.
we take it very seriously, and we don't conclude that it's delusional, right?
I understand that, but perhaps the first time, and then the child recants. But then father brings him back for an itchy penis, and then there is the
Well, you can
FFS.
imagine, and again, I understand he has a thought disorder, so maybe this is not a fruitful
Yeah.
avenue of even discussion, because I don't know how to parse it. But you can imagine someone who has been told by their child, if that's what happened, which of course we don't exactly, well, we know he said it at one point, the
Yes.
child, but we don't know the circumstances. If a child says, I've been sexually abused, you can imagine someone, the first
Of
doctor says no,
course,
son,
of course.
being constantly fearful of this.
And becoming hypervigilant, I
Yes.
can understand that. But once that is discounted over and over again, and even recanted by the child.
Recanted doesn't do much for me. We see recantations all the time in legitimate claims of sexual abuse of children, all the time.
I understand that, but in this particular case, this narrative that father fosters throughout the course of this case became pernicious, and that in itself is the nexus. If I can remind this panel that this is the second care and protection that resulted directly from father's behavior that had to do, the first time I believe in 2017 with domestic violence and these accusatorial issues that were made against mother. There is, she had to file a restraining order, and it's not the only restraining order. There were 3 others where father was placing tracking devices in his girlfriend's car, and with another mother where he accused her of poisoning the child. So there is a little bit more than just his concern here.
No, I agree with that, but it's so emphasized throughout this.
Yes.
Although, as I say, I don't know how you would parse out how much of it is thought disorder and how much of it is
It's just a
explicable.
legitimate concern. But when we have the now nexus of the child being subjected to the care and protection petitions, the child being brought to therapists, perhaps for one thing, perhaps legitimate, perhaps not. And because in one instance, I believe it's with the CHF worker, father is there simply to create evidence for his harassment order that he filed against mother and her husband that was dismissed for lack of evidence. We have not only his academic shortcomings. The therapist reported that it is challenging the child's sense of reality. He refers to his mother as evil and wicked. The school attempted to communicate with father, but they found that they simply were incapable of talking to him because he would just say, "Oh, he's doing spectacularly well," and mother, as opposed to where the child is placed now, was not given any information. He blocked off any contact between the child and mother. At that, and so with that as a basis, I mean, we have the evidence, we have the pernicious effect of father's diagnoses, which he failed to address at every point. And its pernicious effect on the child. There is resultant harm. And in that, the court was allowed to be proactive to protect the child. During the course of the trial, the judge found a fit parent. There wasn't any substantial evidence. My brother's argument as to the judge ignoring evidence, that evidence was brought out on direct examination by mother's own attorney, who just wanted to lay it all out there. The judge found that she was, in fact, a fit parent. The ICPC was approved, and she simply just, allowed the child to go with the most fit parent that was available. She found father unfit, and he was free to challenge that. As far as if I can address any of the jurisdictional issues, once the child's been in Virginia for more than 2 years, once this appeal is over, mother can simply go apply for temporary orders. And at that point, father is free to challenge that custody at any point.
Oh, wait, I don't understand. This care and protection, if we affirm,
Yes.
this case goes away?
No, Your Honor.
Okay, you said if it's dismissed.
If it's affirmed, then the appellate jurisdiction is over with.
Sure, of course.
Mother will simply take her minimus from the juvenile court. She'll take it to the Virginia court, get a motion for temporary orders, and at that point, we can dismiss the care and protection, and we're back to the status quo ante.
In a different state?
In a different state, which father is free to challenge.
Okay.
Thank you.
We will hear next from Attorney Dennis.
Good afternoon, Your Honors. John Dennis for the appellee child. The child urges this court to affirm the findings of the trial court and the order of the trial court.
Is that your substituted judgment?
I've spoken to the child.
Okay, but is the child old enough or competent to make this?
He's 9.5.
Okay. I mean, I don't know what the CPCS guidelines are for substitute judgment versus the child's own judgment, so I'm just asking.
I can tell you his age, and then I had several communications with the child, including December 27th.
Have you ever met the child in person?
No, he's in Virginia. Zoom. Does that answer your question? Okay.
Yeah.
And he's taught me everything I know about paleontology. So we're asking the court to affirm the judgment that father is unfit, not terminating father, that he's unfit, that mother is fit, mother should have permanent custody, and visitation is in the discretion of the mother, who's provided and has always provided father visitation and FaceTime visitation, which you've heard. And I believe he's moving down there.
He being the father now?
Yes.
Okay.
And yes, the child does have a bond and is concerned about his father. That being said, he's happy and is thriving in his current situation. And I would say the record, at pages 69 to 72 of my brief, I list all the instances in the record of father's behavior that have adversely affected the child with citations, including physical altercations the father has been in with former girlfriends, resulting in restraining orders against the father with the child present. You can look at the record at 562, father's own testimony, where he ended up shoving his girlfriend out of the way in the doorway while he's holding the child, and then denied that restraining order obtained by his girlfriend was extended, and the court specifically found father's testimony generally to be not credible. My time, I guess, is, I've got a few seconds.
All right. Thank you very much. These are obviously among the most difficult cases that we have, so it's very helpful. All of your arguments are very helpful to us. And the case is, and of course, we have your briefs as well. The case is submitted. The next matter we will hear is number 23-1214. This is Doe number 527388 versus Sex Offender Registry Board. And we will hear first from you, Attorney Hernandez.
Good afternoon, Your Honors. May it please the Court. Attorney Xiomara Hernandez for the plaintiff appellant John Doe. I'm here today requesting that this Court vacate by client's Level 3 classification and remand the case back to the Board for another sex offender hearing. I would assert that the hearing examiner's Level 3 classification of my client was arbitrary and capricious and an abuse of discretion. As this Court is well aware, in 2021, the Middlesex Superior Court, specifically Judge Wilkins, issued a declaratory judgment finding that it's a violation of due process rights to apply high factor 2, which is repetitive and compulsive behavior, based on the presence of 2 or more separate episodes of sexual misconduct when the offender has not been confronted, apprehended, or charged.
Right, so the board argues, though, that this argument is waived because it was not raised in the Superior Court. Can you just show us in the record where in the Superior Court it was raised?
I would just say, so this specific argument regarding the applicability of factor 2 was not raised, but the general argument that the decision was, is on volume 2, page 2023 of the plaintiff's motion for judgment on the pleadings. There's a headline that says the hearing examiner's decision is flawed.
Wait, tell me, I'm
Yes.
sorry, you're
I'm
speaking
sorry,
a little quickly for
volume
me.
2?
So, tell me where I'm looking now?
Volume 2, page 223. The heading is argument, and there's just a couple of lines there. And I would assert that you could include this argument under that umbrella, which is that the decision, there was an abuse of discretion, is that arbitrary and capricious findings of fact and an abuse of discretion. So the former attorney did not.
Which volume of the appendix is this?
I'm sorry, volume 2.
Volume 2, okay. And you said that's on page
223.
220.
223, and it's basically just a heading of argument. So the prior attorney did not specifically use factor 2 to make this argument, but he used the umbrella argument that the decision was arbitrary and capricious and abuse of discretion. And he did say that the hearing examiner did not adequately apply factor 37. Again, he didn't make the same argument I'm making here today. So I would say.
your argument is that it's preserved because of the term arbitrary and capricious?
Yes.
Kind of protects and preserves any argument of any specific claim as it relates to factor 2, because I, like my panel members, didn't see.
So I wished he would have been more specific, obviously, for the reasons of waiver, but I would argue with what I have in front of me, that would be my best argument that it wasn't waived because of that.
Thank you.
So on the merits, then, the board relies on an unpublished decision of ours, Doe 360651, and to be perfectly clear, I was on that panel, from 2023, which affirmed a classification that used a person's repeated offenses in analyzing his, I think, really his degree of dangerousness. And we said that it was reasonable to consider repeat contact offenders as falling on the more dangerous side of the continuum. In that case, there were 2 victims, and they were diverse. One was a girl and one was a boy. did we get that wrong, and why did we get that wrong?
With all due
And I have an open mind, so I want to hear this.
Yeah, so with all due respect, I do believe that the court did get that wrong. And again, this specific court does not have to make the same exact finding as this previous instance.
It's an unpublished decision, I get that.
Yeah, so I would argue that the Middlesex Superior Court decision in 2021, which the board has accepted the declaratory judgment, if you read some of the language that's within that decision, they were only just talking about the risk to reoffend in terms of the applicability of factor 2, but they were also talking dangerousness. So if you look at addendum page 106 of my brief, which is, I submitted a copy of the Middlesex Superior Court decision, and on 106, there's a part that indicates that there's no data or peer-reviewed literature to support the proposition that repeated sexual offenses is predicate of reoffense or dangerousness, unless the offender is caught. So here, I understand that the hearing examiner used the repetitive behavior to find that my client was more dangerous as a result, versus that he poses a higher risk, which is the case under factor 2. But I would argue that under these circumstances, my client, the same rationale should apply, which is in order for it to apply the higher dangerousness based on repetitive behavior, the person should have been confronted, apprehended, or charged. And also, the hearing examiner already applied the fact that there are 3 victims in this case when he applied risk elevating factor 22, which is the number of victims. So I would say that the hearing examiner in this case basically used that against my client.
Can you tell me what page again the word of dangerousness appears on in the Wilkins decision?
So if you look at the brief that I filed,
I am.
Page 106.
106.
And I guess put a note that it's page 106.
Okay, I see, okay.
So they actually do talk about dangerousness. It didn't specifically apply to the case that they had in front of them at that point because they were dealing with risk of reoffense and not dangerousness. In this case, I believe the hearing examiner tried to apply factor 2 by not explicitly, but by
backdooring it.
Yeah,
but here's I'm sorry, why don't you finish that thought?
Yeah, no, through the back door, because why would they use the fact that my client had multiple victims twice, under factor 22 and under factor 37? They didn't make the same assessment with the other factors that they used. In other words, the other factors that were applicable to this case, they already talked about it once. But with this specific situation, they talked about it twice in factor 22 and then again in factor 37. And I've been doing these cases for like 14 years, and this is the first time that I'm seeing hearing examiners actually talk about the repetitive nature under factor 37 for other useful information related to the nature of sexual.
I mean, this is the third case I've seen that seems to raise this argument in the last 9 months, and there does seem to be a timing coincidence. So I definitely have a concern.
Yeah.
But the challenge you have, though, it strikes me, is, and that Doe, the unpublished case 360651, does say that part of what they're supposed to be doing is considering someone's dangerousness. And here, the examiner did not apply factor 19, which was level of physical contact, because here you, if I recall the facts correctly, you have 3 physical attacks on women and they fought the person off. So there wasn't a completed sex crime, right? And so they don't apply factor 19, but it does seem very reasonable here in this particular case to apply 37 to say if he gets more successful at his attacks, then we're high level of contact, which is a physical force rape, and that's perfectly reasonable for the examiner to consider.
I honestly think that putting it that way, not necessarily saying multiple, not necessarily using the repetitive nature of his behavior, but saying had they not fought him off, he would have been successful in doing something even worse than what he did. I think that actually would have been fair. That is additional information that's not covered under the other factors necessarily. But the number of victims that he had is already covered under another factor, which is factor 22. So I would submit that this hearing examiner essentially tried to get in factor 2 via the back door by applying factor 37. And again, I would just say that, again, factor 37 is for additional information that's out there, not to necessarily repeat the same things that were already talked about within the decision. And I would just assert that if this were to be remanded, I think a level 3 is not automatic in terms of him getting a level 3. My client was 18 years old when he committed these sex offenses. They were committed in 2014. He was close to 30 years old at the time of the classification hearing. Again, there's only one sex offense conviction here, again, committed in 2014. He did get probation until 2025, which will be expiring in the next few months. He does have the love and support of family and friends, and it is in a stable living environment where he lives with his grandparents. And so for these reasons, I would ask that this court vacate the level 3 classification and remand the case back to the board.
Thank you very much.
Thank you.
We will hear now from Attorney Shania.
Thank you. If it pleases the court, David Shania for the board. The board's position, of course, is that the panel got it right in 360651, not just because I argued the case, but I think they took a common sense approach to the idea of dangerousness. And this case is a prime example. This individual sat outside of a Planet Fitness and watched women leaving the premises and then followed them, one of them all the way to her home, and then sexually assaulted them.
The facts are decidedly terrible, no question about it. But one point that your learned opponent makes is that the Wilkins decision is actually much broader than risk of reoffense, but also does include this or dangerousness.
Mm-hmm.
So what's your response to that? Because that's basically saying that, no, you couldn't take you couldn't take dangerousness and put it under 30 because of repetitive assaults. You can't put that under 37.
Now, the focus of Justice Wilkins' decision was the idea that to be repetitive and compulsive, which is the first portion of factor 2, you needed there was no evidence of compulsion. That the board's definition at the time was someone who commits multiple sex offenses automatically is considered compulsive.
But it's not just a matter of semantics. I think he was also saying, and there is no evidence that if you're not caught in between, I mean, the purpose of that factor is to raise risk of reoffense and risk of dangerousness.
Right.
Now, I've always thought somehow it's a miracle. Everyone's always got the same level of both, and that seems so obviously wrong to me. Right? There could be someone who's incredibly dangerous, but no risk of reoffense, or there could be somebody who's huge risk of reoffense, but not very dangerous reoffense.
Right.
And that's SORB has never found that. It's always exactly the same of both.
Can I just touch on that point? The reason is the SORB hasn't addressed it specifically is if someone's considered to be a high danger and a low risk now, they make them a 1. Because the low end...
No, I agree, they should, but I've never seen a report that says, although the risk of dangerousness is high, this is low and it has to be. But in any event, maybe there are some, but I've never seen one. And Wilkinson does say, I mean, this seems like really the gravamen of it. There is no data or peer-reviewed literature to support the proposition that repeated sexual offenses are compulsive or even predictive of reoffense or dangerousness unless the offender is caught. And now we have an examiner, apparently it's now the policy, if I'm understanding what everyone's hinting at here, that at SORB, that those people are more dangerous. And I don't see how you can do that in the face of a judgment you've agreed to that's based on, there's no evidence of that.
Well, I think we can in the sense that Factor 2 only talks about risk of reoffense. It's not a dangerousness level factor. It never was.
Okay.
Justice Rubin extending it out to dangerousness was mistaken in that part of the analysis.
Wilkins.
Justice Wilkins.
Yeah.
You said Rubin, but
I'm sorry.
That's right.
It's just on my mind. But
He's right in front of you.
My name is on it.
but more importantly,
Okay, so you think Wilkins was wrong when he extends it to dangerousness because the factor 2 is only about risk of
Right.
reoffense? Okay.
Do you think he's wrong about there being no peer-reviewed literature or data showing that it's linked to increased dangerousness?
I don't think he's necessarily wrong. I think what the panel in 360651 said is it's common sense. If someone is attacking multiple people or committing multiple sex offenses, and we have to determine what is possible dangerous just as if he reoffends based on his past behavior, someone who reoffends once is less dangerous than someone who
Okay, but that's
reoffends
common sense has, I'm sorry, go ahead, it's
Yeah,
your
right. So
decision.
You had a colleague arguing here earlier today, and I suggested they give you a heads up. So I thought, but I haven't been able to find it, that there's a case that says, actually, this doesn't always follow, risk of reoffense and dangerousness doesn't always follow common sense, and we actually need to follow the empirical science. Is there a case that says that?
No.
No, okay.
The closest, there is one case, and it's a 2006, I believe it's Doe 1211. It was in that group of three that were argued the same day, 3844 and 10216. One of those cases specifically says board regulations do not have to be based on science or studies. And that gives you back to the idea that some of this is basically common sense.
Well, I don't see, I mean, I don't know what that means. Red meat is incredibly delicious, fresh, tasty. It's common sense that it's good for you.
Right.
But it's incredibly bad for you.
Right.
Right.
But factor 19, level of physical contact, doesn't have any references to studies. But it's common sense that if someone penetrates a victim as opposed to someone who just touches victims, the impact on the victim is much greater. And therefore, it's a common sense approach. And I think that sometimes you have to look at all of this in a common sense way. We didn't have this issue before Doe 496501. Doe 496501, the court specifically said we have to separate risk and dangerousness and make specific findings. And they specifically said that dangerousness is based on past sex offending behavior. What the hearing examiner here is saying is, okay, his past sex offending behavior shows that he has an elevated danger compared to other types of sex offenders. The fact that he sexually assaulted 3 people within a basically 4-month period, possibly
So from
more.
now on, everyone who qualifies for number 2, for factor 2, which means they're repetitive, also gets a dangerous thing. And they also have to be compulsive, but they should have their dangerousness elevated under 37 as well.
No, under factor 2, again, you go back to the issue, it can't be just repetitive. It has to be
Okay,
repetitive
but once
and
people who are
compulsive.
repetitive and compulsive are in fact repetitive.
Correct.
So I'm saying, are you now elevating them under factor 37 for increased dangerousness as well?
I don't think so. I think.
Why not?
Because we're looking at, right now, to be repetitive and compulsive, you have to have been caught once.
Many people, from what I've
Correct.
seen, have
But
been.
he's saying every time someone qualifies under factor 2, then if you're doing this for people who don't get factor 2, but you're putting the repetitive part into 37, then inherently every time you have factor 2, you also should have 37.
Not necessarily, because say if you have an individual whose crime is possession of child pornography, and he gets caught a second time, that doesn't necessarily increase his dangerousness.
Well, if it's dangerous to possess child pornography, I'm not sure why not.
Well, because right now, the courts have made it clear that possession of child pornography in and of itself does not exhibit a high danger because there's no evidence that the individual is moving towards contact sex offending. What the board has to prove.
All right, so in every contact sex offense, which is, I mean, I have no idea actually, that we see, it's like 93% of them probably, maybe more. In every single one where 2 is used in a contact offense, are you now saying also their danger, not just higher risk of reoffense, but higher danger, and we're going to take that into account under 37?
No, I think what I'm saying is that depending on the type of sex offending behavior.
I said contact offenses.
Right, even if it's a contact offense, there's different levels of contact offending that cause different
But if
levels of dangerousness.
repetitiveness is itself a sign of more danger, there'll be more victims, it's repetitive. I assume that's the danger you're talking about.
Well, in this case, it's more victims. But if it's an individual who has touched someone once or touched someone, like I had a case years ago where the individual would run up behind women and grab them by the buttocks. I don't know that his danger is the same level as a danger as
No, but it's more that he's done it a bunch of times. It must be more, you must elevate it a little, if in fact repetitiveness.
That's if the hearing examiner decides that under factor 37, his danger is increased because of that type of behavior. And again, it goes to how dangerous is
Everyone with multiple victims then, under factor 2, who makes it under factor 2. See, this suggests to me that you actually are using this as a backdoor around factor 2. If factor 2 applies, we don't go to 37. But if factor 2 doesn't apply, then we do.
I think you can, if it's repetitive behavior, factor 2 might not apply.
But let's say it does. This is what I'm asking.
If it does apply, depending on the level of contact offending, then 37 could be utilized for increasing the danger that.
But you're not doing that right now.
Well, the thing you got to remember, factor 2 is for risk only.
I understand, but I'm saying right now you do not use factor 37 for people who are repetitive and compulsive, only for people who are merely repetitive.
Correct. We're not using compulsive portions of that. The compulsive portion is because if an individual can only be repetitive and compulsive if he's been caught once and then commits another act of sexual misconduct. And this is a prime example. In this case, this individual was never caught.
Doesn't common
so
sense say that someone who reoffends after having been caught is even more dangerous than someone who is a repeat offender and wasn't caught?
No, because Dr. Hansen's studies, both of them say, and the most recent ones also say, that repetitive and compulsive goes to risk and not danger.
So there's a study that shows even if the repetitive behavior is compulsive, it doesn't go to danger.
Right.
Well, why would it go to danger if it's not compulsive? You said you don't need a study. You said it's common sense.
Because it's repetitive behavior, not compulsive. It's repetitive. And it takes it outside of factor 2 because obviously he's not being compulsive.
Of course it takes it outside of factor 2. It makes it less than factor 2.
I guess the point...
I'm not sure. I feel like we're missing each other maybe.
Yeah, I think we... I'm trying to say is that it's a look at whether or not an individual has got behavior, in this case repetitive behavior, that indicates an increase in danger.
And what is the increased danger? It's that they're going to have more than one victim later on?
Yes, DOE 496501 specifically says you have to look at past sex offending behavior to determine what an individual is going to do if he offends
again. But I'm
again.
asking about what the increased danger is. It's not that the crimes are going to be worse, it's that there's going to be more of them.
More victims.
Okay.
In this case, more victims.
Just to be completely transparent, as you know, in DOE 356315, this court faced what was more of a facial challenge to factor 2 rather than a scientific challenge to factor 2. Right. And in a divided decision written by me, we upheld factor 2. And then literally a month later, the board goes before Judge Wilkins and says, whoops, there's no scientific basis. So you might understand that at least one of us, but maybe the entire court, first of all, and I know you have a lot of lawyers, but I have a real concern that there was an issue with duty of candor, that you should have been coming back to us in that case and saying, oh, we're about to tell Judge Wilkins there's no scientific basis. So I'm a once bitten, really 1,000 times shy. I've said this all over the place. Probably there's video of me saying that. So I want to be crystal clear that I think the board and you have a duty of candor. If you're about to come back and tell us, oops, there's no scientific basis for the argument that's being made today, you need to tell us that this week, not a month after our decision, right? You know, in other words, you say, oh, well, it's fine here, but later you come back and say, well, we're wrong about that. We're dead wrong about that. Like, the time to tell us that is now. It's not a month after our decision issues.
I can say I don't know about the other lawyers in the office, but I think I had this argument with Justice Meade many times, and I made it clear that there was no scientific. My argument was the board had the regulatory authority from the legislature to promulgate Factor 2, and at that time, that was what it was promulgated, and that was the basis of my argument every time, was that it wasn't that it was scientifically backed. It was the board's inherent power to create regulations based on their legislative authority. Now, I think I actually, when the Wilkins decision, which I wasn't involved in, and the decision not to appeal that I wasn't involved in, but I did tell Justice Meade, I said, you know, I mean, it's Justice Milkey, I'm sorry, Justice Milkey, I told him, it took 10 years, but you were right. You know, it's just,
about that.
but I want to be clear, I never argued that there was scientific evidence that backed up our reading of Factor 2.
Do you think that we can reach, do you think we can reach waived claims?
I think, well, first of all, you have the right to take things de novo. I think the waiver claim, though, handles a sense that it should be for judicial economy argued down below. But if you see something glaringly wrong, you know, I don't think that it could be argued that you have no right to look into that, because, again, you can look at the evidence de novo if you wish to do that.
What's our authority for that?
Excuse me?
What's our authority to look at it de novo?
I think that it's been done that way from the beginning, because the Superior Court decision isn't controlling in this. It's really an analysis of the hearing examiner's decision. I will point out, and I know you said this is the third time you've seen this issue come up, I have at least 2 more briefs coming with that issue, and maybe a third.
In that first case, you begged us to do a published decision, but the panel, you did not get your wish. And one could argue about that one, too. But in 360651, we didn't analyze, though, whether the hearing officer was double counting.
We did not.
And here, the question is, was there double counting here? Because you, as it turns out, cite Factor 22, which is number of victims. So then that makes using repetitive in 37 number of victims, that seems like double counting.
I don't necessarily think it's double counting, because you got basically here something more than just multiple victims. You have multiple victims can cover anybody who's 1 or 2 victims. Right now, we know there's 3, and there's possibly a number more that the hearing examiner decided not to consider, even though the fact patterns were exactly the same, because I'm not sure how many people, men stood outside PFIT and tracked other women coming from there. There were more, and I think that's a little different. It's taking Factor 22 to the nth level. And I don't think Factor 22 saying it shows an increase in danger, I don't think that covers the level of danger that this individual's behavior created.
Oh, I mean, I have to say, Factor 22 says 2 or more.
Right.
It could have created a chart that said 2, you add a bunch, 3, you add a whole bunch, 4 or more, you just, you know, throw the book at them or whatever.
Right.
And it doesn't say that.
It doesn't say that.
Yeah.
But I think, again, going back to the common sense approach to it, you know, the DOE 496501 made it clear what we have to find for dangerousness. I think someone who behaves in this manner is exhibiting a dangerousness that was higher than the average sex offender.
Do you think that this is an appropriate use of 37 when Factor 19 doesn't exactly apply, because these are, you know, violent attacks, but he didn't succeed? That he picked, he seems to like women who go to the gym, but then that might feed into their ability to fight back.
I did catch that irony.
Yeah, yes, I did too. But had he succeeded, then we would have a physical rape by force.
Correct.
So do you think that is an appropriate use of 37?
I think that's an appropriate use of 37, because the danger is elevated, because now this individual we know attempted to do that. attended to physically
But
rape.
19 doesn't include attempt. It deliberately includes only successful
Correct.
contact,
But that's why you need 37.
or why you aren't allowed to use 37. Right.
I guess it's just perspective.
All right, your time has expired if there's nothing.
I do want to say that was very helpful.
Thank you.
Yes, these arguments were both very helpful. So thank you very much. The case is submitted. This brings us to the final case of this sitting. It's number 24-116, and it is Johnson versus Sunbridge Healthcare. It is partially impounded. I trust that you all will know what the impoundment order is and will not violate it. And we will hear first from Attorney Sobchak.
Thank you, Your Honors. Good afternoon, Your Honors. My name is Attorney Chris Sobchak. I'm here on behalf of the plaintiff, and I would represent the court that of all that heard today, this is probably the simplest of the cases you'll have before you, because all we're asking you is to reverse the trial court's initial ruling on the motion to dismiss, on which the courts can read de novo. The initial complaint alleged a negligence count against a nursing home, the facility, its management company, and administrator, and in the complaint outlined numerous facts how that entities breached their duty, how they mismanaged, and how they failed to enforce his plan of action, which led to multiple incidents, with the final one being choking on a sandwich and dying. Defendants moved to dismiss.
Their argument is but that claim did go to a jury as to the direct care providers, and the jury rendered a verdict of no negligence. So how could the defendants you now want to bring in have liability here?
And, Your Honor, I understand that the plaintiff did not appeal the jury finding, although we after review, there was errors during trial. None of them were to a level that would likely on an appellate be reversed.
And I appreciate that discretion, too.
So in this case, we're not asking to return this case to a new trial. We understand that if the court was to properly reverse...
Yes, but I think you're missing the point. If a jury has already found no negligence was involved in the death, what would the point be of a trial against these people who were, let's say, by hypothesis, wrongly kicked out? A jury has already found no negligence.
Correct, Your Honor. There wouldn't be. We're not asking for a new trial. We're asking for the court just to reverse the two rulings.
Okay, in order to do what?
To prove that the court was wrong. To prove that the...
I'm sorry. So you're not going to try a case against these two people?
Correct. Because on the res judicata, once...
Well, then I don't know what we're doing here.
When a court issues an interlocutory order...
The question is moot.
It's not moot because...
Of course it's moot. It doesn't matter if they're returned to the case because there was no negligence. There's no point to it.
There is still an issue of a trial court making an error.
Trial courts make errors all day long.
Right, and the only time we can appeal
And
it...
if we can redress a grievance caused by it, okay, but what's your grievance? They can't be held liable.
These two individuals cannot.
You agree with that?
I do. I agree with that. But the court's errors should not be perpetuated in the future parties. The courts used a superior court decisions for knocking out claims against a nursing home and administrator, which should have not been.
I agree. I don't agree, but I agree that's what you're arguing.
And in this case, the only time we can appeal it is after final judgment, just because we chose not to appeal the jury's verdict.
Yes, but the final judgment moots the issue. The reason it matters if they're included or not is so you can get money from them for your client. That's why it matters who's listed in the complaint and who's a defendant. What's the point of having them be a defendant? I don't even understand where there's a final judgment in the case. I don't understand. So we reinstate them and everyone goes home?
We reinstate them. I guess they're going to move to dismiss on res judicata, and they will be dismissed, and the case will be over. But the two erroneous rulings...
Why are we wasting so much time and money on this? Somebody's paying someone here. Right? Why would, I don't understand the purpose of this.
Because
I mean, all the time, we don't issue advisory opinions. All the time errors are made. And if they are, You know what I mean? If they amount to something, if they're, germane to something, material errors, of course we reverse them. This one is immaterial now because even if they'd been included, they would have lost because the jury would have found no negligence.
It's not immaterial because the error happens multiple times. The court has ruled that basically a management company administrator cannot be included on a claim where the court already found that there was allegations of negligence.
Well, this is one judge in one courtroom, and if that's a repeated error, it'll come here in a case where then the case is successful, but there should be other defendants. Maybe the people who you won against don't have deep enough pockets because really the money is all in Genesis or whatever. And so in a case like that, someone might appeal the dismissal and there would still be a live issue.
My understanding was that it was still a live issue because there was error. I understand that we're not asking for a new trial. That's why we're asking, as I say, it's a simple case. We're only asking for the reversal of those two decisions.
Okay.
And on the facts of the case, they should be reversed because the judge did found that there was insufficient facts in it to support a negligence claim against one of the entities, even though the complaint had the exact same allegations against all three. And unlike in the medical malpractice case, where this court has held that a captain of the ship cannot be held liable simply because of their position, in this case, the administrator and the management company can be. And later on in the case, and that's this issue of the discretion on the motion to amend the complaint, they actually admitted that they are responsible, both via the documents and
Now,
the
one of the defendants you did go forward against was the nursing home itself.
Correct.
Now, I guess I see how the individual administrator isn't the nursing home itself, right? It's a person. But why isn't the parent corporation of the nursing home itself the same as the nursing home?
Because they're not, and this is one of the errors that the trial court initially ruled in the motion, they were not in this case as the parent corporation. They actually have a separate independent duty. They were here as the management company. So in nursing home companies, oftentimes there'll be a licensee, the healthcare provider, and a management company. Sometimes they're two separate independent entities. Sometimes both of them are subsidiaries of a parent company. In this case, because of what happened in SUNBRIDGE and how they were getting restructured, for this particular nursing home, it just happens to be that the parent company was appointed the management company in this case. But they're not in this case as the parent company. They're only as the management company, which technically is a separate entity.
But when you go to get damages, let's say you had won, and now you need your damages paid. If the management company shows up and says, oh, we're wildly undercapitalized, we have like $14 in this checking account, here you go. Well, where's all the money you earned? Oh, we ship that straight up to the parent company every week. We just don't keep any money here. Couldn't you try to pierce the corporate veil and go to the management company? Do they have to be a named defendant?
If in some cases that could be, and in this case they were functioning as the parent company as well. But it's not. That's why I say they're independent claims because they're not being held liable as the parent company of the entity that went to trial. There are three separate entities. There's the administrator, the management company, and the nursing home. In this case, all three of them happen to be insured by the same entity because the parent company and the management company are one and the same. But they were three separate entities. That's why when we moved on an appeal after the final judgment, we're looking to restore the claims against the two entities, the administrator and the management company, and not the nursing home itself, because that did go to trial, and we respect the jury's finding. With that, I think that's it. It's pretty short and simple. That's why I don't want to have too much time. If there's no questions, I'll yield my time.
Okay, thank you very much.
Thank you, Your Honor.
We will hear now from, probably, Attorney Nahigian.
Good afternoon. May it please the court, my name is Rick Nahigian. I represent Genesis Healthcare LLC, Robert Tabor, as well as SUNBRIDGE of the nursing home. It's hard to know where to begin because we've just been thrown a few curveballs. If I heard this correctly, the plaintiff, the appellant, is asking for the case to be reversed so that it can't be tried and instead dismissed at the trial court level.
Yeah, that seems like good news for you, but...
It does indeed. So let me address the threshold issue. This is and always was a medical malpractice case against a nursing home alleging negligence by its licensed nursing staff. Nothing else. If you look at the complaint.
Well, wait a minute.
Yes.
It's a negligence case. Maybe it's medical malpractice, maybe it's something else. It's a negligence case.
It's a case of medical malpractice, Your Honor, because there are multiple
Okay,
components.
but let's say, because this could be a real case, this case, no negligence was found at all. So, to some extent, this is a hypothetical, well, it is a hypothetical question. I run a nursing home. I'm not a licensed healthcare anything. I live in Palo Alto, but I own a bunch of nursing homes. And if there's one thing I hate, it's paying employees. That cuts right into my profits. So I decide, look, they say some of these people need one-to-one care, I hear. Well, I'm going to hire one person for every 3 beds. I think that should do it. And it totally doesn't do it. And in fact, the nursing staff is doing the very best they can. They are not acting individually negligently. They're with a patient doing something critically important when another one is choking who they're supposed to be supervising. But a human being can't be in 2 places at one time. Why isn't that owner, at least arguably, negligent for causing whatever injury happens?
Well, Your Honor, that's not this case.
Well, but it's, I read the complaint, and it does talk about failure to hire, and it talks about failure to train.
What it doesn't do, Your Honor, excuse me, I interrupt. What it doesn't do is connect the dots, allege the causal connection between that staffing issue and what happened in this case. Now, the plaintiff had an obligation to submit a transcript of this trial. That wasn't done because the plaintiff is not appealing from that result, and in effect has waived this appeal, I do believe. But setting that aside, there are facts to this case. They were tried. The jury heard them. They found that there was
no, I
negligence.
understand that. I understand that. But my question is, why shouldn't you, if that could happen? Of course you sue the nursing home, you sue the nurses. Why can't you sue the guy in Palo Alto who owns it?
Because in order,
maybe it was his decision.
Because in order to do that, you have to have facts that connect.
Well,
plausibly,
maybe summary judgment, but this was dismissed, right? This was dismissed at the complaint stage. Now, of course, there may be no under-hiring facts at all. There may be Mr. whatever, Tabor, I think, he may not have anything to do with any of this. But if he did, as alleged in the complaint, why shouldn't they just be, I mean, how can you dismiss without knowing, right? Something terrible happens at the nursing home. The plaintiff is like, well, I don't run the nursing home, but something bad happened there. So I'm suing these people. I've always thought it was crummy. Maybe I have some reason to think I go in there, I can't find a nurse half the time. I'm going to put in all these allegations, and, you know, and they can deny them, but they state a claim. That's what I don't understand. It seems like it states a claim, even if there are no facts to support it, and that's what summary judgment is for.
well, let me try to explain that. We have a case, Iannacino, which is based on the Twombly case.
Oh, I am
which indicates
deeply aware of that. And you're going to tell me that it's not plausible in America that someone didn't hire enough workers?
Well, setting aside the fact that we're dealing in a vacuum with no facts, it is not plausible to simply assert that someone, some entity was responsible for staffing or policies, what have you.
It's the owner of the nursing home.
Well, let's approach it as a different way, where we have some facts, which is the guy's not supposed to get anything that's like bread, and it seems uncontested that he had bread or cake lodged in his throat, right? I mean, you say in your brief at page 15 that you introduced expert evidence that the cause of death was sudden cardiac arrest, not the choking. But he did have something in his throat he wasn't supposed to have in his throat, right?
I would say no to that because I'm aware of the facts, because I tried the case with Mr. Griffin here. CPR was being administered by 2 individuals with a third assisting and a fourth going downstairs to let the EMTs into the building. So
It's
that
the
they could provide
EMTs who found something lodged in his throat,
sometimes
leading to the question, who are these people performing CPR in a medical facility who didn't find it? But all right, I mean.
I don't understand the train of thought there, but we had someone who was found unresponsive. CPR was initiated. The EMTs arrived. They took over, and the patient vomited. That's probably what happened. I mean, I can get into the facts of the case, Your Honor.
But we're at the allegation stage.
Right.
And it's fair enough to allege, I mean, maybe it isn't, and then, again, summary judgment, or maybe you attach something to the complaint and it's converted to a motion for summary judgment. I'm just having a hard time figuring out, why it's inadequate at the motion to dismiss stage to include the company that owns it and the guy that runs it. And if the guy that runs it, I mean, there's no such thing really as official capacity, and this isn't a government entity. Now, maybe he was an agent of the place acting within the scope of his employment, and maybe, therefore, his employer indemnifies him or something. But that's not the plaintiff's business.
Well, let me just preface this of where we're speaking academically.
Yes, of course.
And I think we see this time and time again. There is a strategy on the part of the plaintiff's bar to bring those entities to go up the corporate ladder, even though a corporate parent is not responsible for the conduct of a subsidiary in the general run of cases.
And there is a strategy on the part of the defense bar to move to dismiss. Everybody's got a strategy.
And the reason why is if you look at the complaint in this case, Judge, the facts section, and look through those facts, there is no connection between a vague or conclusory reference, a label, if you will, to staffing, policies, or regulatory compliance to what happened in this case. These are allegations of first-line nursing failures, which were disproven at trial, but nevertheless, the allegations allege that licensed nursing professionals failed to follow a care plan, failed to follow an ordered diet.
Okay, but if the reason they failed to do so was because they couldn't, they were the best nursing staff in the world, but they needed 8 more people there, then that might be the responsibility of whoever didn't hire enough people, if. Obviously, I mean, now we're like academic on top of academic, but.
Never pleaded, never argued, not the theory of the case, Your Honor. And even if it were, these are licensed nursing professionals. There were sufficient nurses on staff. I mean, we had 3 people taking care of this person when he was found. They have independent duties by education.
When he was found. That's, I mean, right, I don't know. I can't tell you. Maybe this is Shangri-La in this place, or maybe it's terrible, or maybe it's in between. I don't know anything about it.
He was seated in front of the nursing station in his wheelchair when he was found, as I was going to say, to be unresponsive. That's what I was referring to.
Well, those are, the only facts we care about are the ones in the complaint, if we reach that question.
Right, but we seem to be crossing over into what was tried, and
No, I have no idea what was tried, and we don't have the transcript of the trial, so I have no way even of knowing what was tried.
Let me put it this way. We have had multiple cases, including the Spagnuolo case, which I did include in the addendum, which was the subject of a petition for review under Chapter 231, Section 118, and that petition by the plaintiff was denied. So that's something. What it says is that you can't just assign a bunch of labels, policies, staffing, regulations. It's not enough just to assert that to comply with the pleading standard. You have to connect the dots, as the trial judge found. You have to show some kind of causal connection in words, which it shouldn't be that difficult to do, to show what those allegations had to do with the medical result. And time again, we don't see that because it doesn't exist, Your Honor. That's why, as this case proved, after going to trial, the reason it's done is it's a strategy on the part of the plaintiff's bar, and we have consistently been able to turn those back. Most of the cases are dismissed. A couple of them weren't, and one we got summary judgment on, but it's a fact-based thing, and you have to include more than just labels. You can't just throw the word staffing around. You can't just throw the word policy around. You can't just rely on regulations that say, these people are responsible.
Well, I have to say, and I mean, this is not, if someone is not being supervised, how can a plaintiff know before discovery whether it's because the nurse was out smoking a cigarette when he or she should have been inside looking at the patient, or because there's only one nurse on that floor? How is at the pleading stage, how can a person with a decedent know that?
They don't have to know that, Your Honor, to say, this is an individual who is seated in his wheelchair in front of the nursing station, and it was determined that he needed care, and that care was provided. And I believe we had 2 and 3
well,
people
but you're
involved.
yeah, but you're talking about what came out at trial.
Right.
Even before that, we don't know that the plaintiff knew that.
Well, you have to look at if you'll excuse the informality, we need to look at the allegations in the complaint.
No, I understand that, and I see how it's written, but I did dig through it, and as I say, I found references to staffing and to supervision and to training.
But all of those references still are dependent on the idea that there was some negligence which caused the harm.
No, I agree. Obviously, that's correct.
Okay. I mean, I was prepared to argue that the motion to dismiss was correctly decided because of some of the reasons that I already talked about, which is that it is not enough in this day of pleading. Maybe it was back in the days of notice pleading before the case law that we talked about, but now we need to plausibly suggest an entitlement to relief with more than just conclusions. Inadequate staffing is a conclusion. There needs to be facts. How many staff?
We still have notice pleading.
Well, I agree with that. That's true. Okay. But we also have a heightened pleading standard, I think, based
Well,
on...
we have a plausibility standard, but unfortunately, lots of things are plausible that may or may not have happened, right?
But in order to plausibly suggest something, you have to demonstrate in your pleading. You have to tell a story that appears credible.
So in other words, you don't need the expert to say you need 4.2 nurses per 10 patients, but you need some facts that say the decedent was left alone with no one there.
He needed 3 people instead of 2 people, something of that nature.
Well, the real facts that you describe are not the facts alleged in the complaint, but that's not to say you're wrong about what actually happened. There was a trial. I have no idea.
Right. I think there was also one of the issues on appeal was the issue of Mr. Tabor and captain of the ship, and I would be remiss if I didn't speak in his behalf for a moment here. Captain of the ship, that is, the captain of the ship is responsible for everything that happens on the ship, is not applicable to a medical malpractice case. I think that's understood, but I just want to make it clear. I also want to just make it also clear that despite what you may have read in the briefs, the regulations governing licensed nursing home administrators state that a nursing home administrator is responsible for the general administration of the facility. What we're talking about in this case, in this complaint, in the facts section of the complaint, is not the general administration of the nursing facility. It's something different. Mr. Tabor is not simply liable for everything that happens in the facility because of his title, nor is Genesis responsible for everything because it's a parent company or a management company, which, by the way, it wasn't. There are two models. There's management and there's ownership. This was an ownership model. So Genesis's role was to be a parent company, and a parent is not liable for the acts of its subsidiaries under circumstances like these.
All right, I see no further questions. Thank you very much. Excellent argument. The case is submitted. With that, we come to the conclusion of our sitting. I'd like to thank our court officers and our staff for their excellent work as always, and we stand in recess.